For judgment from the supplementary cost list, item number 13.
Is dismissed.
That is your worship.
Cost list. Where's the cost list? Yes.
Lordship. May it please your lordship. Lordship, I'd like to mention item number 6.
Wait,
Lordship.
okay. 6 of
Lordship.
hearing.
Lordship.
Hmm.
Consensus prayer, lordship.
My cost list there. I think it was there with the files only. Yeah, anyway, just submit 6 of hearing, adjournment.
Lordship, the judgment and order was passed by your lordship.
Oh, yeah,
Court
yeah,
below.
okay, okay.
So
So
lordship,
item
this matter may be
6,
listed.
item 6 of hearing. List the matter before any other bench without me.
After 3 weeks, lordship.
After 3 weeks.
I would also like to mention item number 9, lordship. Consensus prayer, lordship.
9 hearing.
Lordship. This matter may also be listed after 3 weeks, lordship.
After 3 weeks.
Lordship.
Item 9 hearing on the prayer of the court. List the matter of the 3 weeks.
Obliged, lordship.
May I please, your lordship? Yes. Lordship, I would mention item number 11. On the 25th to 25, this matter has to be listed on 7. 1 minute. It was come up by mistake. Can I just see the report? Item 11.
Chacha, you had prayed for 17th actually.
Yes, Your Lordship.
Yes. Item 11 hearing. On 25/2/2025, the petitioner had prayed for listing the matter on 17th of March 2023. However, the matter has come up today due to there's a typing error actually, due to a typing error. List the matter on 17/3/2025 for hearing.
Lordship, interim may continue.
Interim passed earlier, shall continue till the next date.
For motion from the supplementary cost list, item number 12.
Please, Your Lordship. This contempt petition is for non-compliance of.
1 minute.
Yes, Your Lordship.
Where is the High Court order?
Your Lordship, is the relevant portion of the judgment is page 17, para 12, Your Lordship.
There are 12.
Yes, Your Lordship.
Yes.
May I read, Your Lordship?
Yes.
As it is submitted that there is a vacant post of chukidar available under the concerned department under the office of the SDO PWD Housing Chengtown in the district of Mon, and also by earlier order dated 15/12/2022, since an interim order was already passed by the court directing the respondents to fill up the said post,
Not to fill up.
not to fill up the said post, the respondent authority, more particularly respondents number 2 and 3, naming engineer-in-chief, Nagaland Public Works Department and the Chief Engineer, PWD Housing Division, Government of Nagaland, respectively will take steps to pass necessary orders for appointment of the petitioner in the vacant post of chukidar, stated to be available under SDO PWD Housing Store at Chengtown, District Mon, Nagaland. The interim order passed on 15/12/2022 will continue till such necessary orders as directed above are passed by the department. Your Lordship, in para number 14, the respondents will carry out the orders as directed within a period of 60 days from the date of receipt of the certified copy of this order that may be served by the petitioner or through the department counsel.
And when was it served?
Your Lordship, an extra 3, page 21. It was served on 20/11/2024.
11. So.
Your Lordship, it elapsed on January.
Oh, okay. Third Learner Counsel for the petitioner, your name?
And solo.
N Solo. Stop. It is stated that this court had right order dated 7/11/2024 in WPC 295 of 2022 had directed the engineer-in-chief NBWD and the chief engineer BWD Housing, Government of Nagaland, respondents number 2 and 3, to appoint the petitioner in the vacant post of chokidar stated to be available under the SDO PWD Housing Store at Chengtown, Mon, Nagaland. Stop. It was also directed that the respondents number 2 and 3 would carry out the said direction within a period of 60 days from the date of receipt of a certified copy of the order dated the earlier date, which I've given 7/11/2024. Stop. Learned Counsel has also drawn the attention of this court to the notice, to the service of the order of this court on the respondents provide notice dated 18/11/2024, which was received on 20/11/2024 by the respondents 2 and 4. No, 2 and 3, by the respondents 2 and 3. Stop. Issue notice returnable within 4 weeks. The petitioner shall take steps for service on respondents number 1, 2, 3, and 4 by registered post with AD within 3 days from today.
For admission, item number 1.
Service on respondents 3 and 4. Okay, it's completed, no? I think it's complete. You have filed the affidavit also.
Lordship,
Mm.
yes.
It's
Lordship, here in this IA number 147 of 2024, I'm paying for condemnation of 490 days.
Are you filing any objection?
I shall submit myself.
Okay, oral submission.
Yes, for some.
Okay, let's see. What are your grounds? $490.
Yes, Lordship. The ground starts on para number 7, Lordship.
Number 7. Judgment is 2023. Yes, please read your grounds.
Lordship. Section A, Lordship.
Yes.
That the copy of the said judgment and order dated 17/5/2023 was received by the branch manager, which was forwarded to the panel advocate and the zonal office. Next para, that by letter dated 22/1/2024, the panel advocate forwarded his legal opinion addressed to the claims department at the Gugat office of the applicant, which was by the office at Dimapur, and forwarded the same on 24/1/2024 to the applicant's office at Gugat, which was received on 29/01/2024. In this legal opinion, the panel advocate advised the appellant to approach the Honorable High Court by way of a letter, whereby the claims department to Gugat forwarded the original claim filed to the manager legal hub for doing the need. That appellant sought advice and direction from the manager by forwarding the original claim filed to perusal and doing the needful. That by email dated 7/02/2024, the Assistant Manager Regional Office Gauhati in respect of the instant case against the judgment and order passed by the learned tribunal from the advocate at Gauhati. That on 14/02/2024, the applicant's Chief Regional Manager, New India Assurance Company Limited, Regional Office, Gauhati received detailed legal opinion dated 12/2/2024 for preferring an appeal before the Honorable High Court Kohima bench, and has also come to a conclusion that if an appeal is to be preferred, the appeal should be accompanied by an application for condonation explaining such delay. In the matter, and the matter was put up before the competent authority seeking advice either to comply or prefer an appeal. And by office note dated 19/02/2024, the competent authority has advised for preferring an appeal. That by email dated 21/02/2024, the regional office Gauhati forwarded the file along with recommendation for filing an appeal to the Bugatti CCA for further compliance of authorities' approval, which was received by the same on 26/02/2024. That by letter dated 26/02/2024, the claims department Bugatti forwarded the original claim file of MSCD case number 02/2019 to the office of the branch manager Dimapur for perusal and doing the needful. That on 26/02/2024, the Bugatti legal hub of the applicant communicated the panel advocate High Court Kohima bench stating that the office shall be standing the file and the appointment letter for doing the needful at the earliest. That by letter dated 6/03/2024, the divisional office of at Dimapur forwarded the original claims file of MSCD case number 02/2019 to the in charge of Kohima micro office for handing over the same to the panel advocate at Kohima for doing the needful. That's on 07/03/2024, the panel advocate received the original claim file from the in charge Kohima micro office. That the panel advocate and his family for the appellant had to leave Kohima town from 07/03/2024 till 26/03/2024 due to a quick notice to his community to leave the jurisdiction of Kohima town. That on returning on 27/03/2024, the panel advocate was disturbed quite a long period, and only after settling down and getting his mind on the right track, the panel advocate started preparing this application along with the accompanying appeal memo. That after preparing of the IA for delay and the accompanying appeal memo, the appeal memo was sent for vetted authenticated by the competent authority, and the same was handed over to the panel advocate for the applicant for filing before this honorable court. That accordingly, in the process of preparing the appeal memo, along with the interlocutory application praying for continuation of delay and staying the impugned judgment and order dated 17/05/2023, there has been a delay of 490 days in filing the conducted MSC appeal. That in view of the aforesaid facts and circumstances, there is delay of 490 days preferring the conducted appeal petition. Para number 8, Lordship, that the applicant respectfully says that the process of obtaining the permission to file appeal has to go through different hierarchy of administrative setup of the company, and in accordance with the administrative prudence and rules that binds the applicants. Sanctions is required to be obtained, processed, and a final administrative clearance is required from the higher authorities for filing an appeal petition before this honorable court, and in the process of such processing procedure, the delay has been caused. Para number 9, that the appellant respectfully states that the limitation period for preferring an appeal has per Motor Vehicle Act being 90 days from date of judgment and order dated 17/05/2023. Limitation expires on 15/08/2023. Thus, there has been a delay of 490 days in preferring the conducted appeal, and as such, the delay is preferring the appeal is neither intentional nor willful, nor due to negligence or lapses on the part of the applicant or appellant, but due to the facts and circumstances which is explained here and above, and also beyond the control of the applicant's appellant. Part number 10, that the applicant.
Yes. Basically, it's your administrative, the formalities.
Yes,
only.
Lordship.
Mm. Yes, Mr. Sharma. What is your objection?
May it please your lordship,
Yes.
I have prepared a small gist, may I forward a copy?
Of course, there is no day-to-day explanation.
Lordship,
It's-
the explanation given by the appellant is not sufficient at all to satisfy this honorable court to condone the delay of 490 days. Lordship. In para 7 of the petition, particularly in para A, alleged that judgment and order received by the branch manager, however, when received the order and when the order forwarded to the panel advocate and to the zonal office not mentioned at all. My submission against para number 7A. Lordship, in para B, no explanation at all from the date of judgment, that is 17/5/23 till the alleged opinion received on 22/1/24 from their counsel, that is 249 days remain unexplained. 249 days unexplained.
Wait. 22/1/24, it is legal opinion. Same one. Okay.
In para B, Lordship.
Yes.
In para C, Lordship, alleged their Dibrugarh office forwarded the file to the manager legal hub when forwarded not mentioned. Para D, Lordship, not when assistant manager RO receive opinion from the Gauhati Council. These are totally vague explanation. Nothing factual to satisfy this honorable court. Lordship, in para G, alleged Dibrugarh office forwarded the office to the Dimapur and when received the file by Dimapur office not mentioned, Lordship. Para H, Lordship, very carelessly and negligently only informed the council at Kohima about the file appeal without sending relevant file, even appointment letter for doing the needful. These are the explanation of the appellant praying for condonation of delay. Even how much negligent they were just informed the council to prepare appeal, but they had not sent the vocalat number, not even send the file, Lordship. In para D, H, Lordship. It is very clear from their petition, Lordship. Para I, Lordship, after 10 days, file was handed over to Kohima office to hand over their counsel at Kohima. In para K and L, Lordship, alleged counsel was having some difficulties from 7/3/24 to 27/3/24. Thereafter, when petitions are prepared and forwarded for signature and get back to file, not explained. Alleged that the council had some problems within the period, and thereafter, when the petition filed, prepared, when it is sent for signatures, nothing has been mentioned in the petition, Lordship. In para 8, Lordship, alleged that it is a cause of movement of file from one table to another for seeking permission to file appeal, Lordship. Entire delay is because of lethargy and inaction of the appellant. The petition filed by the appellant is devoid of material fact and particulars at very belated stage without proper explanation. File appeal at the circumstances. Submission of the appellant delay was not their negligence and willful is totally perverse and no delay to be condoned, Lordship. Lordship, in para 11 of their petition, it is stated, alleged merit of the case to be considered, however, while considering the petition for condonation of delay, merit of the appeal cannot be looked into, whereas reasonable and factual satisfactory explanation of delay is required, Lordship. Merit cannot be considered, Lordship. In this regard, I would like to recite one decision of our apex court in S. Ganesh Rajji death through legal representatives, Narsamana death through legal representative 2013-11 SCC, page 341 para 10, wherein Honorable Supreme Court held that while condoning the delay, merit of the case not required to be considered, Lordship.
Para 10.
Para 10, Lordship. No merit of the case to be considered while condoning the delay. Lordship, the respondent relied upon the following decision of our apex court. In Ikara Ahmed versus Sip Devi reported in 2018 SCC online, all page 5950, Lordship, wherein Honorable High Court of Allahabad referred to a judgment of Honorable Apex Court in Mani Debra Shah versus Municipal Corporation of Barhin, reported in 2012 5 SCC 157. Wherein it was observed as follows, Lordship, para 23. What need to be emphasized is that even though a liberal and justice-oriented approach is required to be adopted in the exercise of power under Section 5 of the Limitation Act and other similar statutes, the court can neither become oblivious of the fact that the successful litigant has required certain right on the basis of the judgment under challenge. And lot of time is consumed at various stages of litigation apart from the cost. Para 24, Lordship, that color of expression sufficient cost would get in the factual matrix of a given case would largely depend on bona fide nature of the explanation. If the court finds that there has been no negligence on the part of the applicant and the cause shown for delay does not take bona fides, then it was condoned the delay. If, on the other hand, the explanation given by the appellant is found to be concocted or he is thoroughly negligent in prosecuting his case, then it would be a legitimate exercise of discretion not to condone the delay. Lordship, our own High Court Division Bench judgment, State of Assam versus Gitarani Kulita and others, 2017 to GLT page 1190. Lordship. In para 7, 8, 9, and 10, page 1190, Lordship. It is a division bench judgment of our own court.
Gita Rani.
Yes, Lordship. Para 7, 8, 9, and 10, Lordship.
Wait. 2017 to GLT 110. This is not the one. 17.
2017 to GLT.
One 1190. This is
Yes, Lordship.
487. Anyway,
Yes, Lordship, in para 7, 8, 9, and 10, the Honorable Division Bench, by referring a judgment of Honorable Apex Court in Office of the Chief Postmaster General versus Living Media India Private, reported in AIR 2012, Supreme Court 1506, wherein it was held that claim on account of impersonal machinery and inherited bureaucratic methodology of making several notes cannot be accepted in view of modern technologies being used and available, and that the law of limitation undoubtedly binds everybody, including the government. Lordship. Lordship, another decision of our own High Court. Lordship, another decision very recently on our own High Court in interlocutory application civil 3 of 21 dated 11/5/23. National Insurance Company Limited versus Nandokanai Pegu and others. Held at para 13, the time consumed in following the administrative procedure and for correspondence between various regional divisional office of the applicant company, the appeal could not be preferred within the prescribed period of limitation does not appear to be a sufficient cause to condone the delay. Further submission of the learned counsel for the appellant that delay cause was in view of circumstances which were beyond the control of the applicant is also not acceptable, as the internal procedures of the applicant company for taking a decision to preferring an appeal under section 173 of the Motor Vehicle Act 1988 has been devised by the applicant company itself, knowing fully well the period of limitation prescribed by the statute. When the applicant company has itself devised its own internal procedures, it cannot be said that same was beyond the control of the applicant. Lordship, in ICICI Lombard General Insurance Company Limited versus Rupnath Brahma Chaudhuri and others, 2017 2 GLT 487, particularly in para 6, Your Lordship. May I read, Lordship?
Yes.
The ground of 99 days delay as alleged in the petition due to movement of file from one table to another. Statement reflected the applicant was casual in all stages of decision-making process in the branch level, regional office level, and in the head office level. Said cause are held not to constitute just and proper or good or sufficient cause for which the connected appeal could not be filed on time. Further held, the insurer, like the appellant, who are in a business of insuring the citizen and goods in the country, have a social responsibility to see that at least they do not become a source of prolongation of the litigation under the social and beneficial legislation. Accordingly, prayer of 99 days delay in presenting the connected appeal is rejected, Lordship. Lordship, another beautiful decision of the Honorable Supreme Court. Commissioner of Wealth Tax, Bombay versus Emesar Rider Club, Bombay, 1994, supplementary to SCC is 603. In para 3 and 4, Lordship, held explanation of delay mentioning the date of movement of documents between the office concerned and the council.
Wait. Commissioner of Wealth Tax, Bombay, para.
Para, Lordship, 3 and 4. Held explanation of delay mentioning the date of movement of documents between the office concerned and the council. Such stereotype affidavit held indicative indifference and condonation of 264 days delay refused, Lordship. These are the sufficient decided cases not to condone the delay. Otherwise, also in para B, Lordship, of their petition, no explanation given against 249 days delay.
Yes, regarding the 249.
Yes,
just
Lordship.
tell me how you are calculating that 249.
From the date of judgment, Lordship,
Right. Date of judgment was
17/5/2023.
17/5/2023
and
till
till 22/1/24.
24.
That is the they allegedly they have received the opinion of the council. In between, 249 days was not explained at all. Yes, Lordship, these are my submissions.
Yes, learned counsel, what is your explanation between this 17/5/23 and 22/1/24? There is nothing between these two. You said that 17/5/23 judgment was received by branch manager, which was forwarded to the panel advocate and the zonal office. Then after that comes letter dated 22/1/24. So between 17/5/23 and 22/1/24, there's no explanation. Any reply?
During this time, Your Worship, the council
Hmm.
in that tribunal.
Hmm.
He had some personal difficulty, Your Lordship, to extract that original copy of that impugned judgment and order related to the appellant, Your Lordship. So because of that, it just brings some delay, Your Lordship.
You get the certified true copy.
Yes, Lordship.
No, but that is not stated there, no? We have not stated anything about obtaining the certified true copy.
Yes, Lordship.
Yes. Anyway. Any more submissions?
According to this this ground
Hmm.
which the opposing councils have mentioned, Your Lordship.
Mm.
Though it is not detailedly mentioned here, but however, we have given each and every annexure, Your Lordship. Your Lordship can find it in the annexure, Your Lordship.
No, regarding the other grounds, it's okay, but I'm talking about this between A and B. Between A and B. The judgment is there, then after that comes the 22/1/24 letter, that's it.
Every date mentioned is there in the annexure, Your Lordship. There's been some personal difficulty on the part of the actual, the first council on the lower court, as well as the council here, panel of here in Gauhati High Court.
No, I'm not done that. That
Yes.
is okay. That is explained. But I'm asking you in between the getting the certified copy and between this letter 22/1/24, that gap has not been explained. Dispose it, chamber disposal.
Right.
For orders, item number 2 and 3.
Yes.
But I'm for respondent number 3 and 4.
What is this for?
This is with regard to the.
Question.
Yes.
And petitioner? Search. PP NIA?
Now the.
Because on the last occasion, the
Please,
PP,
please, Lordship.
okay, PP,
Yes, Lordship.
yes. On the last occasion, you submitted that respondent number 2 had expired. And
Yes,
there
Lordship.
that you may be given some time to obtain the necessary instructions.
Lordship, I've already received the instructions, and I'll be moving an implement application
Mhm.
to implement the present SP as the respondent number 2.
Okay. And what about the trial court records? You are saying that it is not complete. So whether that scan copy has come,
Actually, it was the petitioner who submitted that the trial court has not has been sent to this honorable court.
dated scan copy of LCR has been called for. Right, issues number 23 dated 28/1/25. The same is awaited. It appears that it has not come. 6/3/25. So we'll give another date. How much time will it take to file your IA?
At least, Lordship, 4 weeks time may be given.
4 weeks. You are Mr. Lokesh Kumar.
Lokesh Kumar, PPNI.
Okay. Mr. Lokesh Kumar, learned PPNIA, has informed this court that he has received instructions regarding the expiry of respondent number 2 and wishes to file an IA for implement
Respondent number 2.
yes,
Respondent number 2.
for respondent number 2. No, you are saying that respondent number 2 has expired, no?
Yes, to implead the as the respondent number 2.
New incumbent,
Yes.
yes, and prays for some time to implement the new incumbent as respondent number 2, and prays for 4 weeks time to file the same. The prayer is allowed. The updated scanned copy of the trial court has not been received. Stop registry to issue a reminder to the learned court, learned NIA court for sending the same. Learned counsel Z.N. Muli is present for respondent number
Right, no,
3.
yes.
Respondent number 3. List the matter after 4 weeks. In the meantime, the learned NIA PP shall file his impleadment application.
Please, Your Lordship.
Orders, item number 4.
Need, please, my lord. Lordship, I have filed my affidavit in opposition this morning. Order dated 21/2. We are to exchange our affidavit in our reply within, before a week. But unfortunately, my uncle expired and I had to go from Dimapur to Nebota and also to the village, and that's why a little bit of time was taken. So I don't know whether the opposite party is going to
You
take up today.
received.
Yes, on Saturday evening. at
Saturday
5
evening, I have
5 p.m. I
already-
received a copy.
Oh,
I have
So
already,
Lordship,
LCR also hasn't come.
of LCR hasn't come,
Mm.
and Lordship, LCR will be necessary here. In
Yes.
fact, the LCR was called as early as 21 February 2025.
25.
So 3 weeks should have been more than sufficient for the learned Principal Judge Dimapur to send the reports. So my lord, actually, when the matter was fixed on 21 and the petition was moved, it was the opinion of this honorable court that instead of going for interim or prayer, the
Yes,
matter should be
Lordship.
disposed of.
Disposed
at
of
merits. That
finally,
was the
oh.
consensus of the party. So Lordship, I may be given a short time to file a reply. Though it is revision, then they have raised the issue of maintainability and all that, so it will be proper for,
So
as a
you'll
matter
have
of
to
content,
reply,
I'll take 2
2
days.
weeks, 2
Yes.
days.
2 days, within
It
2
can
3 days
be
I can file.
But the
filed
report
on-
has to come
Report
now,
has to
so
come.
we
So
have
my
to
respectful
issue a reminder.
submission, Lordship, may I pray that the date may be fixed next week.
Mm.
Hopefully, a reminder may be sent to the learned court below to expedite the
Mm.
LCR.
Otherwise,
I don't-
Lordship, it can come up on Wednesday or Thursday if because the direction for producing the records are,
I have no problem
Already
if the
2
matter is
weeks.
listed on Thursday, but the
No, let
problem
it be
is
a 1 week, no?
whether the
Will
LCR
be
can
1
come
week.
within 2 days.
Yeah, that is the problem. 1 week,
Lord,
Yeah.
it's up to.
Then let
my
it be on
Lordship.
17 Monday, Lordship.
17th.
Lordship.
Okay. 17th. 17th is okay. Heard learned counsel for the respondents, Ms. Z. Zimomi, who has submitted that she has filed her counter affidavit. When? You filed
This
when?
morning,
This morning.
Although I
Yes,
have served copies
Okay.
on
This morning.
Saturday.
Learned counsel for the petitioner has prayed for some time to file his reply. It appears that the LCR has also not been received from the Court of Principal District and Session Judge Dimapur. Stop. List the matter on 17th March 2025
For admission hearing.
for admission hearing. In the meantime, the learned counsel, Sri Takamasa, senior advocate, assisted by Mr.
Cindy
Aaron Long, or Cindy Long, shall file his reply, if so advised. Stop. The registry shall issue a reminder to the learned court below to send the scanned copy of the records.
Much of it.
Obliged, Lordship.
For hearing, item number 5.
Everyone is ready.
Yes.
It appears to be a lengthy matter. Anyway,
You take so long. This is the second one of the. Last week, I remember this honorable court has expressed in one of my cases that the writ appeal memo was too big. And this honorable court made an expression that although the appeal memo is so big, the issue is
small.
small and short. So this is also, although
Although the records look big.
records are bulky, but then the issue involved is not that bulky,
Okay,
Lordship.
Okay.
Before I refer to the documents, Lordship, this is a case between the father and the son. Of course, as per the Sima custom, when a village is formed led by one person, when the letter's name is mentioned as called as the village. So the present appellant is Kyoku village, who is the father, and his son was the present respondent, ZK village. So sometime in 1830s, the present appellant, who is the father, his son wants to form another village. So that was allowed. And then as a ritual of forming the village, a dog is being sacrificed. That sacrifice happens to be in a stream under the name and style of Atsukuku Kuki. That is a Sima word. Maybe as a
The name of that stream.
Atsukuku, yes, Kuki. Dog was sacrificed, and this stream came to be known as Atsukuku Kuki. And that was made as the traditional boundary between the two villages, father and the son's village, in short. After forming the village, they have been coexisting peacefully without any difficulty, without any problem. Sometime in 1992, one development under the scheme of CAD, Campec Area Development Scheme, in early 90s, that was very common, in short CADS. That scheme came for improvement of approach road, for improvement of the approach road between Shiusi village to Kyoku village. So when this fund came, the respondents who were plenty, they also wanted a share, that 40% share should be given to us, and the rest should be go to the father's village, Kyoku village. So that was a dispute. So the Kyoku village said, no, our traditional boundary is Atsuku Kuki. Therefore, this is falling under our territorial jurisdiction of the village. Although you have land in beyond the traditional boundary, because what happened over the years, about 40 plots of land belonging to Kyoku has been sold to ZK village. That is after crossing the
stream.
After crossing the stream, after crossing the traditional boundary. We are admitting that, yes, they have purchased, so they have land beyond the traditional boundary. Although you own the land which has been purchased from us, but traditional boundary still remains to Atsuko Kuki, the stream. Like the boundary in Assam and Nagaland. Assam and Nagaland, we have a traditional boundary. Although it is under Assam, Nagas have been purchasing land in Assam.
Beyond the
Now,
boundary.
the name has been given Awimsen, one Aw village. All Aws are residing there. And the Porlingri also. So many Nagas are residing there in that area. Doesn't mean that, yes, you have purchased the land, you are the owner of that particular land, but traditional land, boundary remains as it was before. It is by a stream between Assam and Nagaland. So also, in the present case also, it is like that. So the Ziki villagers have purchased lands from Kyoku. We are admitting, yes, they have purchased about 40 fields beyond the traditional boundary. And they are enjoying that, they are cultivating that. We are also cultivating our own land. But the boundary, traditional boundary is that stream. So that is the dispute. Now what happened? The matter went to STO Sataka. STO Sataka has referred to the TBS court. TBS court has again referred to the PA to DC and all that. So many litigations were there. But then ultimately, it was again referred to the deputy commissioner like that. And then decision was given. And it went to ADC Judicial Senebutu. But the concerned officer at that relevant point of time was under suspension. So it was transferred to Dimapur. And then the ADC has given a verdict. The present respondent, they filed an appeal before the Honorable High Court. And thereafter, it was decided. And against that, we went to Apex Court. And then the Apex Court has again remanded back the matter to the trial court, directing the ADC Judicial to decide. And then there they have made one observation. That is, there is a Hotung's report of 1929 and one Boer who was 10th STU order is 1935 order. So there are two orders that we are not interfering with that. The Apex Court said that. But then again, at the same time, the legal effect of these two documents may be examined by the trial court. That liberty was given. So
Hutton's report of 1929 and the other one was?
one Boer.
Is 29.
Boer is 1935.
Boer is 1935.
I'll refer to all these documents at the relevant time. So the trial was conducted and the trial went in our favor. Agreed by that.
Before the ADC Judicial?
Yes, ADC Judicial Dimapur. And then against that, they have filed an appeal before the Honorable Court against the finding of the ADCJ Dimapur. And then direction was given to the ADC District Judge Senebutu to conduct a free trial. So accordingly, the trial was conducted. And in the trial, in the direction of the High Court, the issue of adverse possession should be decided by the trial court, basing on the evidence. That was the finding given. And relying on the record, you decide. And if the records are not available and insufficient, then you may go for fresh trial also, fresh evidence. That is the direction given by the Honorable Court. And then the trial was conducted in Senebutu before the district judge. And then the district judge has passed the order on 30th July 2019. So before referring to the MPN order, it will be relevant to refer to the two orders which has been passed by the Honorable, which was referred by the Supreme Court. The two orders of 1929, Hotung's order and the Boer's order. Lordship may come to page 17. This is J.H. Hotung's order dated 13th July 1929. May I read?
Yes.
Kyoku village is situated on a spur running east towards the Diza River from the main ridge on which the village is and along which the bridle path runs. This spur is separated from the ridge by a neck of land marked by an eric stone set up by Koishi's order. From the stone on this neck, a stream called Kachu Kikikita runs southwards into the Kutuiki, a tributary of the desert, which formed the boundary between Kyuku and Kukyu. On the opposite side, a similar stream called Shozotuiki runs northeastwards to the Chita stream and the tributary of desert, which forms the boundary between Kyoku and Yemeshi village. This stone in the neck west of Kyoku village and the two streams, Kehitokita and Sozotuki, following south and northeast respectively, etc., are fixed as the boundary between Kyoku and Ziki village. Of the descendants of Pyoto and of Vikehe,
But I think, but.
shall continue to own private land originally cleared and subsequently cultivated by them on the Ziki side of the Sozotuiki and still in their possession at the date of this case. Tohobi of Ziki and Hotobi of Kyoku will be held to have exchanged all land possessed by the one east of the boundary and by the latter west of it. All rights claimed across the boundary now fixed by any other number of either community are ipso facto extinguished. So that is Hutung's order. And next page, page 18. This is the true copy of the order dated 10/12/1935. And the case number is mentioned, and the Ziki village and Kyoku village. Defendants have crossed boundary led by Dr. Hutung in case number so and so. Former order confirmed that only the descendants of Hutu and Viki are allowed to cross the Suzutukuki towards Ziki and cultivate their actual lands. This is passed by one more who happens to be the DC on 10/12/1935. These are the orders which has been which has a reference to the Supreme Court order. Now, I would just like to refer to the Apex Court order.
So only the descendants of Nivuto and Vikie. So who are they? They are from which village? This Vikie and Tohovi. Only the descendants of such and such Vikie are allowed to cross the Shuzotoki towards Zikie. So they're from Keiku village, these two. In the order, this board's order, it says that only the descendants of Niwoto and Vikie are allowed to cross the Shuzotoki towards Zikie.
That is not very clear.
Because only the person's name is there, no?
Yes. Now, kindly come to page 41. I would like to refer to the Honorable Supreme Court's order.
41.
Page 41.
Yes.
It is dated 6/1/1999. Mr. Lordship, correct?
Yes.
Left granted. This has been filed by the present appellant's village. In respect of the land dispute between Ziki village and Kyukhu village in the district of Zeniputu, Nagaland, case number 5 of 1995 was filed before the Devashish court. From the order of that court, an appeal was filed in the court of 2 political assistants to Deputy Commissioners in Zeniputu. Against the decision of the said civil court, civil appeal 1 of 95 has been filed in the court of additional Deputy Commissioner Judicial Dimapur, Nagaland, and is pending. The additional deputy commissioner, in the course of hearing the appeal, has ordered as follows. In the light of the above observation, before concluding pronouncing judgment of the appeal, I would call for additional evidences, if any, to prove that the judgment order of J. Chotum
You
existed
don't have a
and
type copy.
in its appear, no type copy, proper value, and
Cannot read.
as to who is
This
in
is
possession
totally
of.
illegible.
Your Honor, your legislation. There's a
This is just
paper
a,
book.
Oh,
There's a
okay,
paper book
okay.
in the earlier appeal. This is a second round of litigation.
I
appeal.
think it'll be
So
better to
there-
refer to that.
All this, everything is there.
Is it this
The
one?
book is there. It is, yes, yes.
This one, no?
yes,
Mhm.
that is just a reflection of the earlier order.
Okay, okay.
So I'm reading the last para.
Mm.
This order was challenged before the High Court by the first respondent by filing an application under Article 227 of the Constitution, read with Section 151 of Civil Procedure Code. The High Court has set aside this order. Before doing so, the High Court called for the original register, where order of J.H. Hotum dated 13/7/1929, passed in political case number 16 of 29, as also of the NL Board dated 10/12/1935, passed in political case number 82 of 35, are recorded. The High Court has held that these orders are recorded,
That's
are in
important.
existence, and can be accepted as having been passed. It has further directed the additional deputy commissioner not to go into the question as to who is in possession of the land up to 1992. We fail to see how the High Court could have interfered under Article 227 at a stage when the appeal is yet to be decided by the additional deputy commissioner. However, since the High Court took the trouble of actually obtaining the all registers in which the said two orders are recorded, that part of the High Court's order which records that these two orders are genuine documents as recorded in the original register produced before the High Court need not be disturbed. Here is the key area. The additional deputy commissioner, however, will decide all the other questions, including the legal effect of those documents. That means the documents of 1929 and 1935, in accordance with law in the pending appeal. In the premises, the imperial order of the High Court, insofar as it gives other direction on interferes with the other direction of the additional deputy commissioner, is set aside. All contentions raised in the pending appeal by both the parties will be decided by the additional deputy commissioner in accordance with law. The appeal is disposed of accordingly. So it has been directed for a trial, and then in page 122, additional deputy commissioner's order is available, enclosed. It's a lengthy order, but then I will just refer the important portions. This is Zike village versus Gauhati village. It was passed on 30th September 2002. And the finding lordship will find at page 139. As many as 9 issues were framed. 136.
139 is
136.
findings, yes.
One 36 findings. in the second paragraph, Lordship will find. Let me, it is 3 pages, so let me read the finding of the trial court, Lordship. Findings. I derive the authority from Honorable Supreme Court of India to decide all contentious issues raised by both the parties, including legal effect of documents dated 13/7/29 and 10/12/35 in the pending appeal by Honorable Apex Court order dated 6/1/1999. During the trial and hearing the appeal, 29 witnesses, from both parties and their statements were recorded, which I have already mentioned. A. The order dated 13/7/29 and 10/12/35 was found and concealed at Deputy Commissioner's Office, Kohima, for a period of 63 years. B. The parties discovered the documents after 4/12/1992, when head DB Sataka K. Hustu Chimumi ordered the representative of both village to search record from the Deputy Commissioner's Office, Kohima. The villagers could found a set record of 1936 to 1940 register at page 16, Kyoku village records, and then the diaries records are shown. This arose after 1992 only, after the development, when the development came. 137 page, clause 2. These records are true and in existence, but due to laches, the documents are extinguished by itself without execution, and it has no legal effect on both parties. The said documents were cancelled without public expose and implementation, which is part by the period of limitation, section 17 and article 136 of the Limitation Act 1963. 3. There is no available evidence to show both village participated and present during the hearing of political case number 16 of 1929 and political case 82 of 1935. So it was an ex parte order without the parties concerned. 4. The appellant village have purchased 40 plots of land from respondents village from 1951 to 1991. The appellant's village in that case is the present respondent, the ZKA. Para 5. The respondent village has ownership over the disputed land, and they have sold 40 plots to appellant's village, which confirm their ownership and authority over the disputed land. 6. G.H. Hotung's diary reported and published by Northeastern Hills University from 9/10/23 to 30/11/1929 revealed that G.H. Hotung recorded boundary dispute between ZKA and Kyoku on 26/11/1923. So there was boundary dispute, and that was decided, but the involvement of both the appellant's village and respondent village could not be established during recording statements of 15 witnesses of the appellant's village and 14 witnesses of the respondent. So as many as 29 witnesses were examined. 15 by one party and 14 by another party. Order. In terms of what has been decided in the aforesaid findings, I hereby declare that as per the evidences adduced by each party and available on record, Atsutuku Kuki is the traditional boundary between appellant and respondent village. The boundary is as under, and then boundaries demarcation has been given. From so and so, so and so. And then second para. The universal application of law is that nobody buy his or her own land or house. The practice of this method is throughout the world, and nobody would say wrong. The judgment order dated 13/7/1929 and 10/12/1935, if executed within its scope, would have had legal effect on both parties, but the documents were concealed for 63 years. The value and its purpose is defeated and extinguished due to laches. It is evident from both sides that 40 plots of land has been purchased by appellants, villagers from the respondent villagers after 1929 judgments, which exposed itself that villagers does not participate in the proceeding of the above disputed judgment orders. The 40 plots of Chomland terrace fields that has been purchased from respondent villagers shall not repudiate according to Sumi customary law, and the transfer of ownership is effected from the date of sale, and the individual purchaser from appellant village shall enjoy as an individual owner over the land. The land within the traditional boundary shall enjoy by both parties on the basis of individual ownership, but in the matter of community developments such as construction of roads, electricity, water supply, telephone lines, footpaths, resting sheds, individual owners shall not obstruct such community development work and pecuniary interest, and shall be subjected to the decision of the village council of either party, which shall be final and binding, or joint decision of both village council in the matter of common interest. Because of long dispute, I order parties to bear their own costs. Against this order, the present respondent, they have filed an appeal. The plaintiff respondent has filed an appeal as FA number 9K of 2002 before this honorable court. Actually, the issue was on the traditional boundary. The real issue, Lordship will find at page 134 also, just for a moment, can you come to 134? To show that it is about the traditional boundary. 134 on the top paragraph. In the above discussed issue number 3, 4, and 5, I have made exhaustive discussion about possession, the ownership, and traditional boundary. So it is about the traditional boundary. The finding was on traditional boundary, and in page 137 also, in the order, it is clearly mentioned, second last paragraph, order, and in paragraph second last line is the traditional boundary between appellant and respondent village. So it was deciding about the traditional boundary. Therefore, if any development comes, nobody should object or obstruct for community development, and it should be done with the consent of the parties. So that was the finding of the trial court. Agreed by this order, the present respondent has filed an appeal before this honorable court, which Lordship will find at page 139. I will just refer to the relevant paragraph where we are concerned, and hopefully my learned friend will also refer if I have left out any important thing, and especially when some portions are in his favor, then definitely he will refer. So I will just refer to the points which I feel it to be relevant to decide this case. Paragraph 1, Lordship. I will just read paragraph 1 and thereafter paragraph 24. From paragraph 24, I will. This is to show that who are the parties in the case, because a direction by the trial court was that you have not implemented the individual landowners, therefore the adverse possession cannot be decided unless you implement this. But the direction of this honorable court was to decide to arrive to a finding on the adverse possession of traditional boundary, number 1. Number 2, if there is no evidence, then you can go for fresh evidence. And all along, for the last so many years, the case and the dispute was not with the individual, they were the strangers, the third party. Only 2 villages were the disputing parties. But then the trial court has given a direction, given the pass an order that you have not implemented, the individuals are not implemented, so adverse possession cannot be decided. That was the finding. So paragraph 1 is just to show who are the parties. Heard is Mummy Learned Council for the appellant, Zeki village, as well as City Chamber, Learned General Council for the respondent, Kyoku village. It is stated that the Zeki village was either carved out from the Kyoku village sometime in 1920s or Therefore, leading to the circumstances where there now exist two villages, namely Zeki village and Kyoku village. A dispute had arisen between the two villages as regards their intersea boundary and in respect thereof. So there is no individual here. The disputing party is only two, that is the present appellant and the respondent, that is the Kyoku and Zeki village. But then the district judge has directed the aggrieved individuals to file for adverse possession. That is not in terms of the order passed by this honorable court. Therefore, the finding is deviation of the order passed by this honorable court. And he has decided a non-issue, which was not involved before the High Court, which was not the direction of this honorable court. Can we come to page 148? I'll read from paragraph 24. The order passed by,
Para 24.
yes, para 24, page 148, towards the bottom of the page, Lordship will pay. May I read, Lordship? As regards the question of adverse possession, it has been brought to notice by Mr. C.D. Chamber, Learned General Counsel for the respondent, that while deciding the issues number 6 and 7, the Additional Deputy Commissioner G arrived to the conclusion that, having made an exhaustive discussion about the adverse possession and traditional boundaries, the detail thereof clearly spell out that the Kyoku village is the owner of the disputed area, but it noticed that such conclusion was arrived at by the Additional Deputy Commissioner Judicial, merely referring to certain comprehensive discussion that may have been made about the adverse possession and existence of traditional boundaries between the two villages. But upon a perusal of the evidence on record, no such specific evidence is discernible, which would enable the court to arrive to a conclusion as regards the claim of adverse possession by the Kyoku village. Adverse possession is a question of fact to be determined on the basis of evidence on record as to who is under possession and whether such possession amounts to an adverse possession. In the absence of such determination, a conclusion as regards adverse possession cannot be arrived merely upon a comprehensive discussion as sought to be made by the Additional Deputy Commissioner Judicial 25. Accordingly, a conclusion is arrived that the conclusion of the Additional Deputy Commissioner as regards the validity and acceptability of the order dated 30/7/1929 and the Deputy Commissioner is not acceptable, and further that there is lack of appropriate evidence to determine the claim of adverse possession made by the Kyoku village. Consequently, the judgment and order dated 29/2002 of the Additional Deputy Commissioner Judicial Dimapur in Civil Appeal number 1 of 1995 Senebutu is set aside. Upon said judgment being set aside in matters, the matter needs to be remanded back for proper adjudication as regard the claim of adverse possession by the Kyoku village over the disputed land in question. 26. When the evidence on record is examined as regards the question of adverse possession by the villagers of either of the two villages over the land of the other village, I find that there is no complete and comprehensive evidence available on record which would indicate to enable the court to determine the question of adverse possession by the villagers of Zeki village over the land of Kyoku village, as well as the villagers of Kyoku village being in possession over the land of Zeki village. In absence of such evidence on record, it is difficult to determine the claims of the adverse possession by the villagers of Kyoku village. The learned trial court took refuge on the observation made in this paragraph, that is paragraph 26, and he has ignored the direction and observation made in paragraph 27. That is my case, Lordship. 27 is very important because Here, the directions have been issued by this honorable court in what manner the trial is to be conducted and decide. It is clarified that upon the matter being remanded back, the claim of adverse possession by the respective villagers shall remain confined to the disputed land involved in this proceeding, and the same shall not be expanded to any other land beyond the disputed land involved in this proceeding. As the matter is being remanded back for the purpose of determining the claim of adverse possession on the premises that appropriate and adequate evidence is presently unavailable to determine the question, we did not express any view on the merit of the evidence already available on record as regards the determination of the claims of adverse possession. It is provided that while determining the question of adverse possession as claimed in the proceeding, the additional Deputy Commissioner Judicial shall rely upon all such evidences as regards the claim of adverse possession that may already available on record, with a further provision that if the evidence on record is inadequate to determine all the respective claims of possessions of land, the disputed area which may be adverse, additional evidence as may be necessary may be taken. Now, first thing, the honored court below was required to examine all the records, evidence on adverse possession, because till 1990, there was no problem whatsoever. There was no dispute. They were cultivating the land which they have purchased from us, 40 fields. They were cultivating. There is evidence on record that yes, they were cultivating. And we were also cultivating the land. But the traditional boundary was as it was before. So those adverse possession is with regard to the traditional boundary, which was already there, which is settled over a long period of time. But the cultivation, we are not complaining that they are also encroaching our land. We are encroaching. It is not that.
Yes.
In the paragraph, the Assembly Lordship has seen that if the evidence on record is inadequate, if adequate, okay, fine, you decide. But if it is inadequate, then fresh evidence may be taken. We have said that, look, almost half of, if not more, of the witnesses are no longer there. So it will not be feasible to go for a fresh evidence, number one. Number two, when there is enough evidences, which was deposed on the earlier occasion, it was there on record. So on the basis of that, this can be decided. That was our contention. So the going for a fresh evidence was not necessary because everything was there on record. Whether there was record or not, I said, yes, there was record. I will come to that. If no evidence on record, then fresh evidence should be taken. Now, last paragraph, paragraph 28. It is stated that presently the judicial function of determining the civil appeal is being discharged by the learned district judge Senebutu, as the disputed land is within the territorial jurisdiction of Senebutu district and there being a judicial forum available therein. I am of the view that the matter on being remanded back be adjudicated by the learned district judge Senebutu, as it is a long pending dispute at least from the year 1992, if not from the year 1929, between the two villages, and is of now, as the issue for determination had been reduced to the claim of adverse possession. It is provided that the required adjudication be done and completed within a period of 9 months from today. The learned district judge Senebutu, upon receiving the records, shall issue notice upon the put villages, and upon notice being issued, the two villages are directed to participate in the adjudication proceeding without causing any further delay in the matter. LCR be sent back like. Now, whether there is records or not, the case was for determination of ownership and enjoyment of land based on the adverse possession on the traditional boundaries. So the primary issue was on the traditional boundary, not that who owns that, how much. It is not, because it was very clear and not disputed by the parties. So the simple point to be ascertained by the trial court, by the learned court below, pursuant to the order passed by this honorable court, was very simple. That is, who was cultivating the land during the period so as to claim the adverse possession. We are saying, and there are evidence on record that yes, they have purchased 40 fields from our appellant's village. They have been cultivating. So they are the owner of that purchased land. We were also cultivating our land beyond that river by the Kyoku villagers. It is still on record whether we have cultivated or not, whether we have enjoyed the land or not, whether we were parties were in possession of the land or not. That was to be ascertained by the trial court, which was the direction given by this honorable court. So in short, the duty of the trial court was to ascertain whether there was enjoyment of land by the parties. And so far as we are concerned, yes, there are enough evidences about the enjoyment of lands so as to claim adverse, so as to decide adverse possession by different parties. So kindly come to page 156. This is the, I think we should go there. I think we should read the entire imbuing judgment. I will try to highlight. Page 152. There is judgment dated 37/2019.
Annexure 12.
Annexure 12, yes. May I read those?
Yes.
An appeal being preferred by the appellant and filed in the Honorable High Court and registered and numbered as AP so-and-so against the civil appeal 1 of 95 of the Additional Deputy Commissioner Judicial Dimapur, thereby the Honorable High Court decided the other disputes by judgment and order dated 30/10/2018, except remit to this court to adjudicate on the adverse possession raised by the respondent on the evidence taken by the Additional Deputy Commissioner Judicial Dimapur, and if evidence in record is inadequate to determine the claims of adverse possession, additional evidence may be taken by this court. Thus, the case registered and numbered as Civil Appeal 1 of 95 by this court is used as originally assigned by Senebutu Court. 2. While proceeding with the remit case for determination of adverse possession, the respondent declined to go for additional evidence to support the adverse possession. This is because of the fact that almost all the witnesses, many of the witnesses were expired. The claim and praise to this court to hear the parties in the evidence recorded by the Additional Deputy Commissioner Judicial Dimapur as passed by the Honorable High Court. And I would like to mention that the respondents in the present case also agreed that better not to go for fresh evidence since there are enough evidences are there. 3. The brief case is that the Ziki was the son of Kyoku, who migrated from Kyoku village with his father's permission and established Ziki village. The dispute plan relates back to the order dated 13/7/1929 passed by J.H. Hotung in political case number 16 of 1929 and the order dated 10/12/1935 passed by NL4 in political case 82 of 1935 by the additional deputy commissioner of Naga Hills. The boundary dispute arose again in 1992 when the government of Nagaland sanctioned rupees 1 lakh to Kyoku village for construction of road under Tambek Area Development Scheme. Thus, on 13/10/92, the Kyoku village filed a complaint before the STO Civil Sataka,
Yeah,
and the case was
totally. We'll just take 5 minutes break.
no
Come
problem.
back.
To refresh, we can start straight from paragraph 3.
Mm.
Few lines will be on repetition. The brief, somewhere I stopped in the
Page
middle of page
153.
153.
Yes.
Lordship will find after about 6-7 lines CADS in capital letters.
Yes,
Yes.
construction of a
Let me continue up to that.
Yes.
Thus, on 13/10/92, the Kyoko village filed a complaint before the STO Civil Sataka, and the case was endorsed to DB's court, and the matter was decided on 25/2/1993 and reaffirmed the two British Deputy Commissioners' order noted in the above cases. Agreed by the order of the DB's court Sataka, the Ziki village filed an appeal before the Deputy Commissioners in Ibutu, and the case was endorsed to political assistant to Deputy Commissioners in Ibutu for adjudication. The PA to DC Court 2 reaffirmed the DB's court Sataka decision on 4/7/95 with the right to use the private owned land. Thus, the ZK village again preferred appeal against the PA to DC Zenebutu order before the Deputy Commissioners Zenebutu, and thereby the case was transferred to the Court of Additional Deputy Commissioner Judicial Zenebutu by Deputy Commissioner Zenebutu and registered and numbered as a Civil Appeal 1 of 1995, which was later transferred to the Court of Additional Deputy Commissioner Judicial Dimapur due to incumbent was under suspension. Thus, Additional Deputy Commissioner Judicial Dimapur called for additional evidence in respect of the judgment of 1929 and 1935 and their probative value by order dated 9/9/1996. Aggrieved against the said order, the ZK village filed a writ petition in the Honorable High Court against the proceed order dated 9/9/96 and registered and numbered as Civil Rule 174K of 96 and was allowed by the judgment and order dated 24/7/1997 and set aside the judgment and order of the Additional Deputy Commissioner Judicial Dimapur with the direction that the lower court need not go to the second question as who is in possession of the land up to 1992 as it would hit by the law of res judicata. Aggrieved to the judgment of the High Court, a special petition filed by Kyoko village in the Honorable Supreme Court, and the same was disposed of the case by an order dated 6/1/1999, appealed the order of the Honorable High Court with regard to the existence of judgment of 1929 and 1935. However, it was redirected that the ADC judicial to decide the legal effect of the document and other issues raised by the parties. This portion is very important because the ADCJ was directed to decide the legal effect of the document and other issues raised by the parties. ADC has already decided on that point. The then Additional Deputy Commissioner Judicial Dimapur converted the appeal under Rule 29 to Rule 31 of the Rules for Administration of Justice and Police in Nagaland, 1937, and by an order dated 17/7/2002, ordered de novo trial and proceeded with the case and decided the case on evidences produced by the parties and concluded with a boundary demarcation. Aggrieved by the said judgment and order dated 39/2002, the appellant, ZK village, filed an appeal before the Honorable High Court and was registered and numbered as Appeal 9 of 2002. After hearing the parties by the judgment and order dated 30/10/2018, disposed of the case with a finding that to determine the legality and validity of the order passed by the another coordinate court between the same parties involving the same issue, which had been in the meantime finally decided. Such a concept, if accepted, would also be contrary to the principle of res judicata. However, it further directed this court to determine the claims of adverse possession by the respective villagers, which shall remain confined to the disputed land involved in the proceeding, and the same shall not be expanded to any other land beyond the disputed land involved in this proceeding, hence this case. I have heard argument of learned counsel and have gone through the records and evidences of the parties and the learned counsel for the appellant cite reported cases on the point of law, and then points are shown. Do decide the adverse possession by this court before proceed, and then the all are with regard to the law which has been discussed, and then some reference has been done. Now, page 156. on the question and issue of adverse possession, paragraph 8. This will be very relevant because entire case of adverse possession is discussed under this paragraph. He has discussed about the enjoyment of the land, possession of the land, but then the finding was otherwise, contrary to what he has observed in paragraph 8. He has already discussed about the possession of the land, who has purchased, when purchased, how enjoyed, who has enjoyed, everything has been discussed, but then he has not arrived to the issue of
Finding.
adverse possession. And on the contrary, he said that no point has been made out for adverse possession. So it will be very important to take note of this paragraph 8. May I read, Lordship? The respondent in this case relied the evidence tendered by both the parties to claim the adverse possession from the appellants is discussed as follows. The appellant relied on the testimony of Huska Yeptu, PW number 2, GB of Yemishi village and the president of Sumihoho. The neighboring village testified that the appellant are cultivating the disputed land towards Yemishi village boundary, and there is no boundary between Yemishi village and the Kyoko village on the basis of Ziki villagers' cultivation. And further, he testified that he does not know the other side of the Yemishi village. Respondent relied on his cross-examination, wherein he stated that he was not aware whether these villagers from the Ziki have inherited the land or acquired the land by purchase. The appellant replied on Ketobi's PW3 of Yemishi village and Veshito PW4 testified that there is no boundary between Yemishi village and the Kyoku village in the disputed area. Further, Veshito PW4 also in his cross-examination stated that he can say that Yemishi is having a common boundary with Zeki village because of the fact that the following persons from Zeki has been cultivating the land bordering Yemishi village. They are Shoto, Ihito, Toniho, Vihoi, Sohito. Further, Vihito PW5 HGB of Shiosi village. The neighboring village testified that he knows no boundary between Yemishi village and Kyoku village. He have seen Zeki villagers cultivating the disputed area, and the cultivation of the disputed area is reaffirmed in his cross-examination, and named the following persons from Zeki village who are cultivating the disputed area, namely Shoto, so many names are given. This testimonies reveals that appellant, the Zeki villagers are cultivating the land towards the Yemishi village boundary and not Kyoku villagers. More so, in the testimony of Sosito PW12, the Zeki village testified that after the demarcation of the boundary of Chichoto, our family decided that all properties on the Kyoku site would be enjoyed by my elder brother, and all the properties on the Zeki, that is G is wrongly typed, site would be enjoyed by me. And this arrangement continues till date. So this is between the two villages, father and son, enjoyed differently. They have been cultivating their respective fields. In his cross-examination also revealed that the entire dispute area is cultivated by Ziki village. The purchase of land made by Chuhusho and Bihoto from Keike village was more than 20 years ago. This testimony is more reliable to the extent of boundary between the two villages in lockerheads as decided by the Honorable Supreme Court and the High Court. Further, it reveals that there is inherited property by way of family partition as well as purchase of land in the disputed area. This purchase of land in disputed area was further corroborated with Ziki2 PW13 of Ziki village appellant testimony, where in his examination in chief he testified. Apart from the fields which he brought from Kyoku village, the villages have jointly cultivated the disputed area for many years. This joint cultivation of disputed land is further testified by Bihoi, PW16, and Zeki village. In the cross-examination, he contradicts himself by stating, presently, these three persons, namely Nivako, Sihovi, and Kutubi and Keiko villagers are cultivating their fields below my field in disputed area. It is pertinent to mention that OK PW18, the chairman of the ZK village, the appellant in his cross-examination revealed that besides the demarcation by the British, it is my knowledge that ZK had purchased more than 40 plots of land from Kyoku village in the disputed area. This is my knowledge as well as in the knowledge of ZK villagers. I am not aware of any person from Kyoku village purchased the land in the disputed area. Now here a pause. The present appellant's village, Kyoku village, who were the respondent in the trial, defendant in the trial. We have never purchased from them. It is they who has purchased from us and they are enjoying. We have no dispute whatsoever in that 40 fields which they have purchased over the years, they are enjoying and cultivating. We are also cultivating our own land. Therefore, it is surrounded. Their land has surrounded our area also. Our land has also surrounded their area. But those are all beyond the traditional boundary of Atsukoku Kuki. Let me continue. Ketovi DW3, HGB of Yemishi village, the neighboring village. In his cross-examination, he testified that he is the son-in-law of Tukuho, GB of Kyoku village. The disputed area lies in between Cheta and Akuitu. The disputed area is cultivated by both sides, and he particularly knew of Hoke and Shoto from Seki and Kotubi, and Nivako from KK village, Kyoku village. His statement of common boundary and the statement of the three other GBs of his village contradicts each other, and which of the statement is correct is in the knowledge of both the villages. Besides, Keneto TW number 4, HGB of Kyoku village, stated in his cross-examination in chief that present disputed land belongs to Kyoku village, and accordingly, our villagers are cultivating the disputed land, which is purchased from our village. Zeki has no other land. In the disputed area, Zeki village have purchased about 30 to 40 fields from Kyoku village. This purchased lands corroborated with Hoke PW18, the chairman of the Zeki village. Further, Keneto GW4 testified that he also possessed land in the disputed area, 1 field towards Cheta, 8 fields towards Mizupu stream, 2 fields towards Kachekika Kita, 6 fields towards the road leading to Akuitu, and above the border road 2 fields. He has not sold any of my fields to Zeki villagers. In the disputed area, none from my village has purchased any land from Zeki village. In the disputed land, we can carry out 2 to 3 cycle cultivation at the stretch. Okatu DW Den of Kyoku village testified in his examination in chief that he also possessed land in the disputed area, and his land is situated towards Chitaho and Akuitu. His village were engaged in cycle cultivation in the disputed land. The first was in the year 1967 at Chitaho. The second was in the year 1983-84 towards Akuitu. But as regards the third cycle cultivation, which was proposed to be engaged in Chitaho, the same was restrained by the government. He personally engaged in cycle cultivation during the year stated above. Zeki village also engaged in cycle cultivation with us, but over the land purchased from Kyoku village. It is a fact that the land belonging to his clan was within Kyoku village, and at no point of time at Zeki village. In his cross-examination, he further testified that in the disputed area, my clan had 15 fields from the same. We sold 11 fields to Zeki villagers, and now owns only 4 fields, 1 in Chitao and the 3 in Akuedo area. Sujito PW12 of Yemishi village, an elderly person from neighboring village, in his re-examination in chief testified that presently these 3 persons, namely Nivuko, Sihoi, and Kutubi and Kikihu village, are cultivating their fields below his field in the disputed area. The testimony corroborates with Bihoi PW16 regarding the purchase of land from Kyoku village. Pituhu, GW 14 of Kyoku village disposed his examination in chief that the disputed land belongs to Kyoku village and he have also land in the disputed area. ZK village has also an access to the land in the disputed area, which is purchased from his village. He is also testified that he is aware that Kyoku village has undertaken cycle cultivation in the disputed area for 2 times, the first being in the year 1967 and the second year in the 1984. Basing on all these evidences, the district judge ought to have decided the issue of adverse possession on the traditional boundary. The dispute was between the 2 villages for the last 93 years and not with the individuals. 9. On perusal of the above testimonies, it reveals that there is inherited property as well as purchased land in the disputed area by ZK villagers. Josito PW 12 of ZK village, an elderly person from neighboring village, in his re-examination in chief, he testified that presently these 3 persons, namely Nibuku, Sihui, and Kotobi, and Kyoku village, are cultivating their fields below the field in the disputed area. This testimony corroborates with Vihoy, PW 16, wherein in his re-examination he stated that purchase made by his father from Kozipu was many years ago, even before he was born. Kyoku villagers sold the land to KK villagers after demarcation of the boundary. 3 villagers of Kyoku village, namely Kotobi, Sihoy, and Nibuku, have been cultivating the field for many years, and he presumed the fields belonged to them by inheritance. He was sure that the land purchased by his father, late Kibishi and Kizipu of Kyoku village, must have been purchased after Hoton's demarcation of the boundary. The boundary dispute regarding jurisdiction of the village between Kyoku village and the ZK village was adjudicated and reached its finality. Hence, considering the above possession of land in the disputed area, adverse possession does not arise. Since the Kyoku village also admitted the purchase of land by ZK villagers are not in dispute, this reveals the ownership of disputed area belongs to Kyoku village. Unless the Kyoku villagers would not have purchased the land of Kyoku village in the disputed area. Thus, the possession of individuals' land in the disputed area reveals sparsely scattered or mingled in between the individuals' land or private lands of the contending villages. On the above premises, it shows the Kyoku village or individual land owners of Kyoku village cannot claim adverse possession on its own land owned by individuals of Kyoku village. 10. On the above discussion, and the Honorable Court in FA number 9 of 2002 judgment found that there was no complete and comprehensive evidence available on record taken by the Additional Deputy Commissioner Judicial Dimapur is inadequate to determine the claims of adverse possession. Thus, ordered this court may take additional evidence. This possession still exists as respondent has declined to go for additional evidence, but to determine as per the records available. Hence, both the parties have actual possession of land by individual and publicly in the disputed land. The appellant's learned counsel have rightly pointed out that there is no hostile possession of land with intention of possession of the property to be acquired under the rights of adverse possession. Besides, there is no express or implied denial of owner's title by the possessor of land from the original owner in the alleged disputed land, but the individual's land ownership owned by inherited or purchased land in the disputed land have no dispute among them as admitted by the parties in this proceeding. More so, there is no definite disputed area of individual possessors and its continuity to prove how and when it came to possession of the land over a period of more than 12 years, as the appellant relied in so-and-so case. By going through the evidences of the parties and contentions, this court found it is a mere dispute of boundary dispute between 2 villages, which is not subject matter to be reopened in this case. The parties' claim of adverse possession between the two contending villages have not shown distinct individuals' land in dispute and claiming for adverse possession from the original owner of land, as the disputed area is not a public land or community land, but the dispute land belongs to different individuals' land. Therefore, each individual land must have hostile possession on its own different continuity of possession of land claiming adverse possession in the disputed area, which is not made out by the parties to determine it by this court. The individual land possessor has brought no grievance but peacefully cultivating their own land by way of inherited property or purchase till the government has issued restraining order as precautionary measure of law and order. Therefore, the learned counsel has rightly pointed out that the claim of adverse possession raised by respondent has not supported by pleading or evidence, and without there being proper pleadings is of no consequence and will not come to the rescue of the parties in hand. And the case is referred. As the Honorable High Court in its judgment found that there was no complete and comprehensive evidence available on record to enable the court to determine the question of adverse possession still exists in this judgment, since the whole area of disputed land has no grounds to claim adverse possession, as the jurisdiction or boundary of two villages or contending villages has already settled by the higher courts and attained its finality. This is also wrong. In this proposition of law, the village council cannot agitate for adverse possession at one stroke for the whole landowners without specific claims unless the individual landowners come for claim of adverse possession, if any. Before parting with the record, this court directs the appellant and the respondent village to cultivate their individual land as before and shall maintain peace and harmony and exercise individual rights and land ownership as per the laws in any matter without claim of village boundary. In case of restraint order passed by the Deputy Commissioners in Ibutu against both the villages to cultivate the disputed land, if any, the Deputy Commissioners in Ibutu shall bound down the two contending villages in this case under relevant provisions of law, if necessary, and release the restraining order within 2 months from the date of passing this judgment and order. And then order. The adverse possession of the disputed area of land in this case is not made out as raised in the Honorable High Court. Hence, case disposed of with the liberty to file for adverse possession by the individual landowners, if still aggrieved and advised so. The Deputy Commissioners in Ibutu shall take steps within 2 months from today as regards to pounds. Failing to take steps for the bond between the parties within the stipulated said period, restraining order issued by the Deputy Commissioner Dimapur shall also treat as set aside up to the said period. Issue copy of this so. So the trial court has arrived to a finding that the issue of adverse possession is not made out. Now, as I have referred to your lordship in paragraph 8, which is at page 156, the issue of possession is appreciated in this paragraph. It is a long paragraph where detailed explanation and discussion have been made. So he may have forgotten
That's
what he
para
has,
8.
para 8, page 156. He has discussed everything about the possession, who is possessing the land, since when all these evidences are there. But then he has taken refuge to the finding of the High Court in paragraph 26, and he has forgot to consider the finding in paragraph 27 of the High Court, which has clearly mentioned that on the basis of the available evidence on record, you can decide the issue of adverse possession. And if the records evidences are not sufficient, you can go for fresh evidence also. That was there. And then towards the end of the finding, individual owners were directed to approach the court for adverse possession. They were not the disputing party in the case. So this is not in terms of the order passed by this Honorable Court. Therefore, the order passed by the learned District Judge Zenebutu is leveled to be interfered with, and a fresh trial is necessary. To conduct strictly in accordance with the direction passed by this Honorable Court. Both the parties have accepted the direction of this Honorable Court and proceeded for a trial. But then the trial court has deviated from the direction and order passed by this Honorable Court.
Originally, the dispute arose regarding the boundary, isn't it? Boundary
Traditional
between
boundary.
between the two villages.
Traditional boundary.
Then in para 12, the court again says that the jurisdiction of the boundary is already settled by the high courts.
From where he
And
has
then-
arrived to that conclusion also, I have doubt.
So where is that? If it has attained its finality, why is the litigation going on?
That's right.
Anyway,
And then even the order of 1929, the Hotung's order and Boer's order of 1935,
Mm.
the observation of the ethics court. On one hand, ethics court that we are not touching with the order passed by the Honorable High Court, but at the same time, they have given liberty to the trial court to decide the
On the
legal
two
value
judgments
of the
also.
two documents and which the trial court has decided. Trial court has decided, the ADC Judicial Dimapur has decided what is the effect and implication of the two orders. And looking at the entire judgment, impugned judgment passed by the learned district judge, more or less, he has examined and decided which is in favor of the plaintiff. And if any direction is issued so as to conduct a trial strictly in accordance with the order passed by this Honorable Court, neither the present appellant and the respondent would not be prejudiced. They should have a fair trial and ample opportunity to present their respective cases. So it is a fit case for interference by this Honorable Court and a fit case to be remanded to the District Judge Zenebutu so as to try the case strictly in accordance with the order passed by this Honorable Court. And he has derived a new theory of directing the individual landowners to file
to file the case.
the case for adverse possession, who were never a party in the entire proceeding. And it was nobody's case also to decide. Therefore, the order passed by the District Judge Zenebutu is liable to be interfered, and a fresh trial should be directed to be conducted by the District Judge Zenebutu strictly in accordance with the order passed by this Honorable Court. I would conclude, Lordship. Much obliged.
Yes. Yes.
Maybe can we take the paper book? Because except for the judgment of the High Court in the previous first appeal, which was given in the year 2018, and the subsequent trial court order,
Zenebutus.
all the records are there. This is the record.
Okay.
There's nothing new evidence, since no new evidence was taken.
So all the evidence
Everything is here,
available
which
is
was
still-
there before, in the first appeal of the 2002, and which was there before the trial court, even now, this time, against which this appeal is prepared. Everything is there, except the judgment passed in 2018 in first appeal 2000, which first appeal 9 of 2002, and the judgment which was passed on 30th. Yeah. Yes. 37.
The present one, 37. 3719.
Yes. Yes. 37 2019, except this two. Your Honor, whatever may have been the traditional boundary, the boundary was settled in the year 1929. Your Honor, may kindly see that order once more. where they have said, in the paper book, my lady may kindly come to page 29. Page 29. May I read the
Yes.
portion 1, 2, 3, 4, 5, 6, 7, 8, 9, 11. My lady may kindly come to
On the top.
from the top line, the 11th line.
Yes.
This stone in the neck west of Gekhe village and the two streams, Kachekita and Sozotovuki, following south and north respectively, are fixed as the boundary between Gekhe and Gekhe village. So this is the boundary. 1929. Your ladyship, Gekhe is the present appellant, Gekhe is the respondent. Boundary settled. This is the boundary, which was fixed in the year 1929. Then may I just read further the query that my lady had put. But the descendants of Piyoto and Vieke, no other shall continue to own private land originally cleared and subsequently cultivated by them on the Czechia side, that is on my side. Only the descendants of these two persons. The boundary is set. The boundary has been set. It's like this, my lady. The boundary is set, and they own some land on my side. For example, the boundary of Nagaland and Assam is set. I own some land, or Mr. City Chairman owns some land on my side. They can come and cultivate. But the boundary is set. That doesn't mean that they coming and cultivating land here will change the boundary. I can go to Assam and cultivate my land. But the boundary is set, has already been set.
So it says the boundary will be
Boundary will
between
be
Geko village and the two streams.
this
such
this
and
stone
such,
in the neck
going
west
south
of
and
Geko
northeast.
village. You can check this. This is the boundary. And our case all along has been that the boundary has been set, this boundary has been set way back in 1929. And this should be the boundary. And in 1935, the next page. Who were the defendants? My lady, Geko were the defendant, Czechia was the plaintiff. Now, the defendants, page 30. The defendants have crossed the boundary laid by Dr. Hutton in political case number such 29. So, Geko villages had crossed the boundary. So, this order, Bohr was the DC then in 35. Hutton was the DC in 1929, Naga Hills. Former order confirmed, that is 1929 order confirmed, that only the descendants of Piyoto and Vieke are allowed to cross these two streams, Suzokuki towards Czechia and cultivate their children. Only the descendants of these two persons, no one else. Same thing repeated again. Clear? My lady, now it's very clear. Only the descendants of these two persons from the side of Kirke, the present appellant, can come towards my side and cultivate. But that doesn't change the boundary. The boundary is already set. Now, keeping these two orders in mind, may we proceed? Because, my lady, what has happened after that? It landed up in the civil. It was actually an appeal against the Dovash's court order. Now, de novo trial was conducted. I was the appellant there. I became the plaintiff.
Yes.
And I did not succeed. The land, though the ADCJ Judicial Dimapur ignored these orders, these two orders. Ignored these two orders passed in 1929 and 1935 and decided the disputed. Your Honor, may kindly see the Putin and Bose order says the boundary is here, and which I'm saying yes. They say no, the boundary is here. So I lose some land. Now, this became the disputed area. What ADC did, ADC decided to solve the problem by dividing the disputed land into two parts. And that's how we landed up here in the year 2002 by filing the first April 9 of 2002. In that case, my lady, this honorable court said, the issue was, no, we said the matter has already been decided way back in 1929, and the boundary dispute cannot be reopened. And this partition of the disputed area is totally wrong. And therefore, that Supreme Court also has said now the two orders, because of the earlier order passed in the civil rule in a writ petition, these two orders are really genuine orders, they are in existence. What will be the legal effect this side? Go and decide before the trial court. And therefore, this honorable court went into the legality of those two orders. Okay, these two orders are there. Now this honorable court found that DC then, way back in 1929 and 35, the DC had the judicial powers to decide dispute, adjudicate dispute. Therefore, the ADC, a coordinate bench cannot overrule or ignore the order passed by another coordinate bench way back in 1929. It can only be overturned in appeal by a superior court. It is res judicata. The boundary has attained finality. The order passed in 1929 and 1935 is a judicial order. Therefore,
let's go back to that
yeah.
again, the High Court's.
Yes, my lady,
Yes.
can I just, I'll go back.
Okay.
That becomes very important,
Okay,
this
okay.
order of the High Court. But may I just give the brief outline?
Yeah.
Brief outline.
Okay.
Therefore, but the boundary is settled. But there's a pleading, one paragraph pleading. In fact, we very well know, no matter whatever may be the evidence, unless there's proper pleading, it is of no use. There's one paragraph pleadings in the written statement. That was not sufficient to establish for a plea to plead adverse possession. Yet the High Court says there is some pleadings, and we did not challenge that. We have accepted it now. We cannot caution that now. But there's no sufficient material evidence to decide the question of adverse possession. This is the material. This was the material, which is also now, there's nothing new has come in. So there's no material on record, no evidence on record to decide the issue of adverse possession raised by the defendants. Therefore, the matter is remanded back to the trial court only on the limited question to decide the issue of adverse possession. Whether any portion of land can be claimed by the present appellant village, then respondent village, on the basis of adverse possession. And there's no adequate material now. So therefore, the trial court can examine the materials on record, as well as liberty is given to the respondents, the present appellant, to adduce additional evidence. They went back to the trial court, they got an opportunity, yet they declined to adduce any evidence. So the trial court could not have in any other way disagreed with the High Court, saying that there's enough material on record and decide otherwise. High Court has already held. We'll have to go back to the judgment. High Court has held. That is the reason why High Court did not decide on the issue of adverse possession. Could not decide. And so opportunity is given. Court will not direct you lead evidence, further evidence. Court will only give liberty. Liberty was given. It was not grabbed. Therefore, the trial court, which is a subordinate court to the High Court, how will the trial court decide that there is evidence and the High Court was wrong? So trial court rightly decided there's no evidence. And now we're back on the same material coming before this honorable court and saying that there is material on record. Can this honorable court respectfully go? There was a single bench. This is also same coordinate bench. Can this court now take a different view? It can only be taken by a superior court now, saying that the earlier order passed in 2019 What's wrong? There was material on record. There was material on record. Adverse possession could have been decided. Now they are raising this issue that when in 2019, this honorable court has already decided that there's no material on record. Therefore, you send it back again, giving that opportunity. That is the issue, main issue. Even otherwise, for my lady, what is adverse possession? You all know? For to succeed on the ground of adverse possession, that means I agree that I'm not the true owner. I agree that he's the true owner. Yet I've occupied the land. The entire world knows, so he should also know. It has been continuous occupation for a long period of time, at least not less than 12 years. Yet he did not go to court. Therefore, by my virtue of hostile possession, for more than 12 years, I have a right over that land. So that means even today, I have possession of the land. To claim adverse possession, first I must have possession even today. And I must show that this possession is hostile to the true owner. Only then I can succeed on the plea of adverse possession. The evidence will show that they don't even have evidence on record. But even their own witnesses will show that they don't have even possession. Forget about hostile possession. Now, I need to. Now, lady, I have prepared, since the material is such, for the sake of convenience, I prepared a written argument, which I can just, I've also.
Yes, supply to them.
Yes.
Yeah.
Now, lady, I'll just read through, then wherever necessary, I'll pause and then go to the judgment. I'll not read the entire thing. But and how did it land up here? The history of litigation. Married from two. Czechia, son of such and such, migrated with his followers from Gauhati village sometime in 1830. Krishna allowed Czechia and his followers to migrate with their respective land out of 12 areas of Dreamland that comprise Gauhati village. Czechia and his followers took away 3. That is the land that belonged to them. Thus, Czechia village came into existence. Consequent thereupon, that Krishna, along with elders, demarcated the area settled on Czechia and his followers as under. We'll skip this part. 3. After about 100 years of peaceful coexistence, a dispute arose between 2 villages. Mr. J. H. Houghton, the then DC of Naga Hills, registered the dispute as poll case number 16 of 1929 and decided the same on 13/7/29, along with Dobashis, Kohoto, Kakho, Kesheto, and my lady. I have mentioned the page number of the paper book, the relevant documents, and also the present Impleadment. The order of Mr. J. H. Houghton, dated 37/29 in poll case number such and such, was affirmed by order dated 10/12/35 in poll case number such, issued by his successor in office, Mr. N.L. Bo, Deputy Commissioner of Naga Hills. In the year 1967 or thereabout, the dispute between the 2 villages arose yet again. The 60s, the 70s in the state of Nagaland was an era of constitutional as well as extra-constitutional authorities. The dispute between the 2 villages were referred to an extra-constitutional authority, that is the Rajabio of the so-called federal government of Nagaland. By an order dated 1467, both parties were fined by violating the order of J.H. Houghton dated such and such. The parties thereafter lived in peaceful coexistence up to the year 92-93. In 92-93, a sum of ₹1 lakh was sanctioned to Gauhati village for the construction of a road. 80% of the road fell into the Czechia territory. Accordingly, Czechia village raised objections, and thereupon, on the principle of land ownership, the SDO Civil Sataka directed that 40% of the amount be given to Czechia village. Thereafter, the dispute between the 2 villages arose yet again. Gauhati village on 13/10/92 filed an application before the SDO Sataka claiming a boundary dispute between the 2 villages. The SDO Civil Sataka endorsed the matter to DB Court to decide the matter in accordance with law. But order dated 5293, the DPS court Sataka held that the materials by Kirkuk village had already been settled by then British government, and the DPS court reaffirmed the same. Seven. After about a year, Kirkuk village appealed appeal against the decision of the DPS court. The DC endorsed the same to PA to DC Zonoboto. The BA to DC by order dated 4/7/95 accepted the fact that since the boundary between the two villages has been demarcated by the judgment of 1929, the same is proper and valid. However, by the same judgment, half of the disputed area was given to Kirkuk village. 8. Chekia village then filed present civil appeal. That is the previous civil appeal 1/95. The appeal on application of both parties was transferred to Dimapur. The additional deputy commissioner Dimapur took up the matter on 9/9/96, issued an order calling for additional evidence in respect of judgment of 1992 and 1995 and the provided value. Chekia village filed a writ petition in the High Court against the aforesaid order dated 9/9/96. The said petition was registered as civil rule number such, was allowed by judgment dated such 24/7/97. Against the judgment of the High Court, a special leave petition was filed by Kirkuk village. The same was disposed by an order dated 6/1/99. The said order upheld order of the High Court with regards to the existence of judgment dated 1929 and 1935 and their acceptance as having been passed. However, it was directed that the ADCJ decide the legal effect of the documents and other issues raised by the parties. During the course of the proceedings by an order dated 17/7/2002, the appeal was converted from an appeal under Rule 29 to an appeal under Rule 31 of the Rules for Administrative Justice, 1937. Upon conversion of the appeal from 29 to 31, the Honorable Additional Deputy Commissioner Judicial ordered a renewal. A total of 9 issues were framed. Chekia village examined 15 witnesses and Kirkuk village examined 14 witnesses. The trial was concluded and by judgment and order dated 39/2002, the Additional Deputy Commissioner Dimapur disposed the appeal number 1/95. By this judgment and order, in most frivolous and illegal manner, the order of 1929 and 35 were ignored and the boundary between the two villages reset. Hence, Chekia village preferred an appeal before the High Court, which was registered as FA number such 9K of 2002. By judgment and order dated 30/10/18, the Honorable High Court set aside the judgment and order. Your Honor, my lady, kindly note that the order passed by the ADC judicial has been set aside. It's no longer relevant, and nobody has challenged that setting aside of that order. Passed by the Additional Deputy Commissioner Judicial in Civil Appeal number 1/95. The Honorable High Court held that the order dated 13/7/1929 passed by J.H. Newton and order dated 10/12/1935 by NL Board are valid. While disapproving the finding of the Additional Deputy Commissioner Judicial Dimapur that order dated 13/7/29 of J.H. Newton is unsustainable, the Honorable High Court has held in the paragraph. Miley, I'll be reading this from the original judgment. So may I just go now? This is what how it's happening.
Let's see the judgment of FA.
FA 9/2002, page number 3010, page number 139 of the appeal memo. Mary the entire judgment. Mr. Such and such, non-counsel for the appellant, Chekia village, as well as Mr. Such, senior counsel for the respondent to the village. It stated that the Chekia village it is stated that the Chekia village,
You're reading from page,
page 139,
oh, from the beginning.
from the beginning. It is stated that the Chekia village was earlier carved out from the Kirkuk village sometime in 1920 or thereabout, leading to it's 1820 actually, leading to the circumstances where there are now exist two villages, namely Chekia village and Kirkuk village. A dispute arisen between the two villages as regards their interstice boundary in respect of thereof there exists an order dated 13/7/29 of J. Houghton, the then Deputy Commissioner, Nagar Hills District, passed in poll case number such. The said order of 13/7/29 inter alia describes certain landmarks and provide that landmarks described therein are fixed as boundary between Chekia village and KK village. Boundary fixed, 1929. It is also accepted that the order dated 13/7/29 of J. Houghton, the then Deputy Commissioner, was confirmed by order dated 10/12/1935 NL Board and the subsequent Deputy Commissioner, which was passed in poll case number such. In the aforesaid background, a dispute was raised by the Chekia villagers with regard to the maintenance of boundary between the two villages, which resulted in proceeding before the Dobashis, which is an accepted authority under the rules for administrative justice and police in Nagaland. The judgment and order dated 25/2/93 of the Dobashi resulted in favor of Chekia, and the same was assailed by KK village before the Deputy Commissioner, resulting in case number sub at 95. The Deputy Commissioner Zanaboto, before whom the said appeal was filed, had preferred to refer the dispute for its adjudication before the political assistant, which existed at the relevant point of time. The decision of the political assistant, dated 4/7/95, resulted in an equal division of the land between Chekia village and KK village. The said decision of political assistant numbers, dated 4/7/95, was assailed by Chekia village before the additional Deputy Commissioner Zanoboto. As the appropriate presiding officer was not available, the proceeding was transferred to the Court of Additional Deputy Commissioner Dimapur, resulting in civil appeal number 1 of 95. In the course of proceeding before the Additional Deputy Commissioner J. Dimapur, the Chekia village had raised an issue that by order dated 37/29 in poll case number such, the boundary between the two villages had already been determined by J. Houghton, the then Deputy Commissioner, and it is being so. Proceeding before the Additional Deputy Commissioner, Dimapur is not maintainable as is being hit by the principle of res judicata. Accordingly, it was the stand of Chekia village that no further adjudication of the boundary dispute between the two villages can be made, as the same was already determined in order dated 13/7/29 of the Deputy Commissioner in the official political case number 16 of 29. In the resultant situation, the Additional Deputy Commissioner Dimapur had passed the order dated 9/9/96 in civil appeal 1 of 95, wherever it was provided that additional evidence be taken as regards to the existence of the judgment and order dated such of the Deputy Commissioner J. Houghton, the order of 9/9/96 of the Additional Deputy Commissioner J. Dimapur was assailed by the Chekia village, resulting in a writ petition before his court civil rule number such of 96. The said writ petition was given a final consideration by the judgment and order dated 24/7/97, when it was provided as such. Having said enough, I now remit this case to the then Additional Deputy Commissioner J. Dimapur to decide as to whether the present proceedings is hit by the principle of res judicata, accepting the order dated 13/7/29 passed by J. Houghton, the then Deputy Commissioner, Nagar Hills District, in political case number 16 of 29, and affirmed by NL Board, the then Deputy Commissioner Hill District, in its order dated 10/12/35, passed in political number such, is valid and in existence. Consequently, the order dated 9/9/96 passed by ADC Dimapur was as quoted above is hereby set aside. Being agreed by the official judgment and order of this court in civil rule number such, to the extent that the existence of the order passed by J. Houghton and then Deputy Commissioner was accepted, and appeal was carried out by the KK before the Supreme Court, resulting in civil appeal number such. The Supreme Court, by its judgment and order dated 6/1/99, provided as follows. However, since the High Court took the trouble of actually obtaining the old register in which the said two orders are recorded, the part of the High Court's order which records that those two orders are genuine documents are recorded in the original register produced before the High Court need not be disturbed. The Additional Deputy Commissioner, however, will decide all other questions, including the legal effect of these documents in accordance with law in pending appeal. A reading of the judgment and order of Supreme Court dated 6/1/99 would require us to arrive at the conclusion that the question as regards the existence and validity of the order dated 13/7/1929 of J. Houghton, the then Deputy Commissioner, was accepted to be valid order. Having accepted so, the Supreme Court further provided that upon the matter being remanded back, the Additional Deputy Commissioner J. will decide all other questions, including the legal effect of those documents in accordance with law, which has to be understood to be the two orders dated 13/7/29 of J. Houghton, the then Deputy Commissioner, passed in political case 16 of 1929, and the order dated 10/12/1935 of NL Board, the then Deputy Commissioner in political case number 82 of 1935. In other words, any legal issue other than the issue of existence and validity of the aforesaid two orders are to be decided by the additional Deputy Commissioner. But at the same time, the Deputy Commissioner would also require to decide the legal effect of the aforesaid two orders. In the resultant situation upon the matter being remanded back, the Additional Deputy Commissioner J has passed the order dated 39/2002 in Civil Appeal number 1 of 95. The said judgment and order dated 39/2002 of the Additional Deputy Commissioner J in Civil Appeal number such is assent in this appeal by the Chekia village. As already noted,
We'll resume at 2.
May I please, Your Lordship?
Yes.
Lordship, my apologies, Your Lordship, but I beg to mention hearing item number 8, Your Lordship.
Eight.
Yes. Lordship, with the consensus where if this will come up on April of 7th.
When?
April 7th.
April 7th.
Yes.
Steno is not there, just contents. What about item 7? I don't think we'll be able to complete this. You're in item 7.
Yes, what?
Item 7.
7A.
FA, na? Mm. Oh, yeah. We heard him, but. Okay, let's see if there's enough there. Item 8, okay. On the prayer of the General Council for the parties, list this matter on 7th April 2025 for hearing.
Obliged, Your Lordship.
Please, Your Lordship. Lordship, I beg to mention item number 10.
Yes. Item 10. What do you want?
Let it come on 7 April.
This one also, 7th.
Yes.
Item 10. No objection, no? On the prayer of the General Council for the parties, list this matter on 7th April for hearing.
Report 42,
Yes.
paragraph 9.
We're on 143, paragraph 9.
As already noted, the scope of determination of the additional Deputy Commissioner J. Dimapur has been limited by the Supreme Court in its judgment and order dated 6/1/1999. To the extent as indicated above, that is, the additional Deputy Commissioner Judicial shall decide all other issues involved in the dispute, except for the issue as to the existence and validity of the two orders dated 13/7/1999 of J2 Heaton, the Deputy Commissioner, and 10/12/35 of NL Board, the subsequent Deputy Commissioner, and further that the additional Deputy Commissioner J would also determine the legal effects of the officer two documents. Accordingly, this court examines the correctness of the order dated 30/9/2002 of the additional Deputy Commissioner J. Dimapur within the confines of the officer requirement provided by the Supreme Court. The learned counsel for the appeals contends that the additional Deputy Commissioner J. Dimapur, while passing the judgment and order dated 30/9/2002, had exceeded the officer limitation imposed by the Supreme Court in its judgment and order dated 6/1/1999. The effect that the additional Deputy Commissioner J had decided the issue by determining the boundary between the two villages. Mr. Siti Jamir, senior counsel, appealing for the respondent Kohima village and on the other hand justifies the judgment and order passed by the additional Deputy Commissioner J. Dimapur on the premises that the additional Deputy Commissioner J had rightly determined the boundary between the two villages in as much as the record as well as the evidence on record reveals that in fact there was no determination of the boundary between the two villages by J. H. Houghton, the then Deputy Commissioner. To that extent, reliance has been placed upon the evidence led by some of the survivors of the period 1929 who were present along with J. H. Houghton at the time when the said decision dated 13/7/29 was made. Mr. Jamir, senior learned counsel, also raised an issue that the Supreme Court in its judgment and order dated 6/1/1999 had required the determination of legal effect of the documents referred therein, meaning thereby that it does not remain confined to the orders dated 13/7/29 and 10/12/35 passed by the two then respective Deputy Commissioners. Heard the learned counsel for the parties in detail. The first and the foremost consideration before this court in determining this appeal could be as to whether the additional Deputy Commissioner J. Dimapur in passing the judgment and order dated 30/9/2002 had exceeded the limitation and restriction imposed by the Supreme Court while remanding the matter back for its adjudication. The said issues assumes further relevance in the background of the submission of Mr. Siti Jamir, senior counsel, appealing for the respondent Kohima village deterring that the stand that the orders dated 1929 and 10/12/1935 of the then two respective deputy commissioners does not exist. The said submission of Mr. Jamir, Learned Senior Counsel, has regards the non-consistence of the two orders dated 13/7/29 and 10/12/35 of the two then respective deputy commissioner could have to be looked from the background of the conclusion arrived by this court in its judgment and order dated 24/7/1997, the civil rule number 174K/1996, and the judgment and order dated 6/1/1999 of the Supreme Court in civil appeal number 57/1999. In its judgment and order dated 24/7/1997, in the civil rule number such, this court had arrived at a categorical conclusion based upon the records produced in that order that the order dated 13/7/29 passed by J.S. Houghton, the then deputy commissioner in poll case number such, and dated 10/12/1935 passed by N.L. Board, also the then deputy commissioner in poll case number such, are valid and are in existence. In the said context, the Supreme Court also arrived at a conclusion that the High Court having taken the trouble of going through the all registers as regards the two orders and having passed the said order, no interference in such conclusion is required. Accordingly, in view of the said categorical conclusion of the High Court as well as the Supreme Court, this court unable to accept the contention of the respondent Kohima village. The further question as to the existence of the two aforesaid order dated 13/7/29 and 10/12/1935 is required to be adjudicated again. Accordingly, the court is of the view that the said two orders are in existence and the same are valid for the purpose of this proceeding. As regards the other aspect, the Supreme Court in its judgment and order dated 6/1/1999 had provided that upon the matter being remanded back, the additional deputy commissioner J shall decide all other issues involved in the dispute. The said provision has to be understood from the point of view that the additional deputy commissioner J will decide the dispute by accepting the position that the two orders dated 13/7/29 and 10/12/35 are valid orders and they are in existence, and having accepted so, the other issues involved in the dispute between the parties could be decided. The court had taken note of the written statement of the respondent, Kohima village, in the proceedings before the additional deputy commissioner J, wherein in paragraph 13F, a specific stand has been taken that the respondent village is in continuation and uninterrupted possession over the disputed land in question for over 60 years. And therefore, even assuming the orders dated 13/7/1929 and 10/12/1935 are to be valid, still the respondent village had acquired a right over the disputed land under the law of adverse possession. From the said stand taken by the respondent village in the written statement, it has to understand that the other issues involved in this dispute as referred by the Supreme Court in its judgment and order dated 6/1/1999 also includes the claim of respondent village as regards the acquiring the right over the disputed land over law of adverse possession. From said point of view, the provision of the Supreme Court in its judgment and order dated 6/1/1999 that the additional deputy commissioner J shall also decide the legal effect of the documents referred, meaning thereby the legal effect of the two orders dated 13/7/29 and 10/12/35 would have to be determined in the context of the claim of respondent Kohima village as regards the adverse possession over the disputed land. In the aforesaid context, when the judgment and order dated 13/9/2002 of the additional deputy commissioner Dimapur in civil appeal number such is examined, it is seen that it is taken note of that the additional deputy commissioner J had relied upon the oral evidence of the witnesses, namely of respondent Kohima village, including certain witnesses who had accompanied J.S. Houghton at the time of delivering the order dated 13/7/29 and had arrived at the conclusion that the order dated 13/7/1929 of J.S. Houghton, the then deputy commissioner, is not sustainable inasmuch as the said order was arrived without taking the appropriate evidence and the respective parties were not given the opportunity of hearing before such order was passed. The court is of the considered view that such conclusion could not have been arrived at by the additional deputy commissioner J. Dimapur, inasmuch as the earlier order dated 13/7/1929 was also passed by coordinate court, and therefore, while examining its legal effect upon the dispute raised by the parties, the additional deputy commissioner J. Dimapur could not have gone to the extent of determining the validity and sustainability of the said order dated 13/7/2029. Such position, if accepted, could lead to disastrous consequences when it could be acceptable proposition that a coordinate court would have the jurisdiction to determine the legality and validity of an earlier order passed by another coordinate court within the same parties involving the same issue, which had been, in the meantime, finally decided. Such concept, if accepted, could be contrary to the principle of res judicata. Further, the Supreme Court in its order dated 6/1/1999 had also provided that upon a matter being remanded back to the Additional Deputy Commissioner J, an adjudication could be done as regards the legal effect of the two documents, that is order dated 13/7/1929 of J. Houghton, as well as the order dated 10/12/35 of N. Board, the two deputy commissioners. In order to understand as to what the Additional Deputy Commissioner J is required to do with regards to the aforesaid two orders, we have to examine the meaning of the expression legal effect. As per the Black Law Dictionary, the word legal, amongst other means, of relating to or involving law, generally falling within the provisions of law. The word effect, amongst other means, something produced by an agent or cause, result, outcome, or consequences. Accordingly, expression, the legal effect, has to be understood to mean the result, outcome, or consequences of something within the provision of law. When the opposite expression of the meaning of legal effect is taken into consideration, to understand as to what the Additional Deputy Commissioner J is required to do with regards to the orders dated 13/7/1929 and 10/12/1935 of the two then Deputy Commissioner, we have to conclude that the Additional Deputy Commissioner J shall only determine as to what could be the result, outcome, or consequences of the said two orders by treating the two orders to be valid and to be in existence, and cannot go further and determine as to whether the said two orders are in existence or as to whether the said two orders are valid or not. In such view of the matter, the conclusion arrived by the Additional Deputy Commissioner J. Dimapur in redetermining the order dated 13/7/1929 passed by J. H. Houghton, the then Deputy Commissioner, would have to be unacceptable. But at the same time, the court cannot be oblivious to the aspect that respondent Keheke village had also raised an issue of adverse possession over the disputed land in question. Even if it is accepted that the boundary between the two villages had been determined in the order dated 13/7/1929 by J. Houghton, the then Deputy Commissioner, still it cannot be said that over the years since the year 1929, there could have not been any changes as regards the possession of the land by the villagers of the two villages, as it is possible proposition that some villagers of Zekia may have been in possession of some land of Keheke village, and at the same time, some villagers of Keheke village may have now been in possession over some land of Zekia village, which could be at variance from the boundary contained in order dated 13/7/1929. Even though the boundary may have been determined in the order dated 13/7/1929 of J. Houghton, the then Deputy Commissioner, the claim of adverse possession by the respondent Keheke village deserves a proper determination. As regards the question of adverse possession, it has been brought to the notice by Mr. Siti Jamil, senior counsel for the respondent, that while deciding issue number 6-7, the Additional Deputy Commissioner had arrived at the conclusion of having made an exhaustive discussion about adverse possession and traditional boundaries. The detail thereof clearly spelled out that Keheke village is the owner of disputed area. But it is noticed that such conclusion was arrived at by the Additional Deputy Commissioner J, merely referring to certain comprehensive discussion that may have been made about the adverse possession and existence of traditional boundaries between the two villages. But upon a perusal of the evidence on record, no specific evidence is discernible which could enable the court to arrive at a conclusion as regards the claim of adverse possession by Keheke village. Adverse possession is a question of fact to be determined on the basis of evidence on record as to who is under possession and whether such possession amounts to adverse possession. In the absence of such determination, a conclusion as regards to adverse possession cannot be arrived at merely upon comprehensive discussion as sought to be made by the Additional Deputy Commissioner J. Accordingly, a conclusion is arrived at the conclusion of the Additional Deputy Commissioner J as regards the validity and acceptability of the order dated 13/37/1929 of the Deputy Commissioner is not acceptable, and further that there is lack of appropriate, my lady, this is important, furthermore, that there is lack of appropriate evidence to determine the claim of adverse possession made by Keheke village. Consequently, the judgment and order dated 29/2002 of the Additional Deputy Commissioner J Dimapur in Civil Appeal number 1/1995 Zone number 2 is set aside. Upon this judgment being set aside, the matter needs to be remanded back for proper adjudication as regards the claim of adverse possession by Kayaka village over the disputed land in question. 26. When the evidence on record is examined, this is important again, as regards the question of adverse possession by the villagers of either of the two villages over the land of the other village, I find that there is no complete and comprehensive evidence available on record which could indicate or enable the court to determine the question of adverse possession by the villagers of Chekia village over the land of Kayaka village, as well as by villagers of Kayaka village in possession over the land of Chekia village. In absence of such evidence on record, it is difficult to determine the claims of adverse possession by the villagers of Kayaka village. So no evidence on record as at that point of time, which is the same evidence we have today also, because no additional new evidence was taken. It is clarified that upon the matter being remanded back, the claims of the adverse possession by respective villagers shall remain confined to the disputed land involved in this proceeding, and the same shall not be expanded to any other land beyond the disputed land involved in these proceedings. As the matter is remanded back for the purpose of determining the claim of adverse possession on the premises that it is sent back on the premises that the appropriate and adequate evidence is presently unavailable to determine the question. We do not express any view on the merit of the evidence already available on record as regards the determination of claim of adverse possession. It is provided that while determining the question of adverse possession as claimed in the proceeding, the additional Deputy Commissioner shall rely upon all such evidence as regards the claim of adverse possession that may already available on record, with further provision that if the evidence on record is inadequate to determine all respective claims of possession of land in the disputed area which may be adverse, additional as may be necessary may be taken. It is stated that presently the judicial till then. So, my lady, this honorable court has clear findings that no evidence, and therefore I'm sending it back. We're sending it back. I'm not expressing any merit of what as regards to the evidence on record, but I cannot decide the issue of adverse possession because there's no evidence on record. And liberty is given to the Kayaka village to complete further evidence. My lady, we finally come to page 152. Page 152. 152. The judgment of the trial court on remand. May I just read paragraph 2. While proceeding with the remit case of determination of adverse possession, the respondent declined to go for additional evidence to support the adverse possession claim and prays to this court to hear the parties in the evidence recorded by the additional Deputy Commissioner Dimapur. So
no additional evidence was used.
The respondent, the present appellant, accepted the earlier judgment of this honorable High Court. It was not challenged, it was not taken up and challenged in the Supreme Court, saying that there's enough material on record to decide the question of adverse possession. Accepted that there's no adequate evidence. So it is remanded back. But when they go back to the trial court, though they're given an opportunity, decline to. So additional evidence doesn't mean only those witnesses can be called who were there earlier. Oral as well as documentary, additional. So oral means new witnesses can also be brought in, decline. So accordingly, Your Ladyship, I'll not read this entire judgment, it has been read. So held that, no. And since he also finds that there's no evidence on record to decide, just like what the Honorable High Court had decided. And on possession, on the possession, he also found that no. And the land in these villages are owned by individuals, not by the village. Not by the village as a whole. Pockets of lands are owned by the individuals, just like in any other Naga villages. So he says, if you want to make a claim, because I may have certain land in Assam, and I'm having possession right there, but that will not alter the boundary. But if I'm being denied those the right there, I can come and make a claim. I can file a suit for adverse that on the basis of my possession over there for a long period of time, I've acquired the right over the land. That is all he was saying. But he has found that there's not enough evidence, just like this Honorable High Court found earlier, on record to decide the issue of adverse possession. And they have declined to leave additional evidence. And whatever material was there, he was discussed, and he did not find that this is enough to decide the question of adverse possession. Now, to cut short, I have prepared a list of authorities. Regarding adverse possession. I'll just read, I've colored the principles and just the principles in order to save time. The first one, a person claiming title by adverse possession must show that his possession is adequate in continuity, in publicity, and in extent. It is also required to show when possession becomes adverse to the true owner. Second one, the plea of adverse possession has to be proved by the party raising it on the basis of proper pleadings and evidence. The party raising the plea of ownership through adverse possession must first admit ownership of the true owner. Thereafter, proved by adequate evidence that the issue of actual, peaceful, and uninterrupted continuous possession of the property for more than 12 years to the exclusion of the true owner with the element of hostility. This one, again, is the third and fourth one. Any amount of evidence on or proof adduced before there being proper pleadings is of no consequence and will not come to the rescue of the parties. Fifth one, adverse possession requires all three classic requirements to coexist at the same time, namely, nec B, adequate in continuity, nec com, adequate in publicity, nec precario, that is adverse to a competitor in denial of title. Number 5, party claiming adverse possession must plead and establish. Number 6, party claiming adverse possession must plead and establish title by adverse possession. There cannot be any variance between pleadings and proof. Here, my lady, paragraph 13F is the only one. In the written statement, paragraph 13F is the only where they have pleaded 13F. Okay, page 70 of the paper book there. Paper book.
Page 70.
70. F. F, paragraph F. That even assuming that not admitting the decision in case number 16 of 129 to be valid, the respondent being in continuous and uninterrupted possession, exercising dominion over the suit land, which falls within the traditional boundary, for over 60 years, acquires the title and ownership of the suit land under the law of adverse possession. This is the only. It says, because of uninterrupted possession, exercising dominion over the suit land, which falls within the traditional boundary for over 60 years, acquires the. So they're saying they're still in continuous occupation for more than 60 years on this land, and therefore they have acquired the right. That's all I'm saying. Now,
This was the written statement from before the IDCJ.
yes. It starts from page number. That was page number 57. 57. 57. Starts from 57.
Mm. Okay.
Now, let me know. When a person makes a claim on based on adverse possession, he must say who is the true owner of that land. The land should be specified. This is the land, or this is the area, and who is the true owner. And he must also say that since when he came into occupation of that land, and the nature of his occupation. And on the date he claims a right over the land by way of adverse possession, he must still have possession of the land. And that is his pleading also. And the Honorable High Court also says that there's a pleading that there's an argument that there's a submission that they're still in possession, And that, based on the possession that occurred there, right? Now, Your Honor, if the evidence is there, Your Honor, we kindly come to page. Written argument. Written argument. Written argument. Your Ladyship, may kindly come to page number 8 of my
Your written argument,
written argument,
page?
page 8.
Hmm.
From paragraph 18 onwards, I've dealt. If your lady wants, if my lady wants me to read it, I'll read it, but I've dealt with the evidence of each plaintiff witnesses as well as the defendant's witnesses.
Okay, okay.
And this shows that they don't even have the evidence of possession, apart from adverse possession.
Para 18,
18,
19,
19,
18,
20,
19,
20,
20,
19, 20, 21, 22, 23, 24, 25, 26, 27, 28. And I have in fact quoted the relevant portion. I've also given the page number from the paper book, as well as the appeal memo. If this honorable court goes through this, it will be very clear that not even adverse possession also they have not established. But the most important part is, most crucial part is, can this honorable court now decide that there is adequate evidence on record when the coordinate bench of this honorable court is already decided there is no adequate evidence and therefore on the basis of same material before the courts, same evidence.
okay. Any reply?
Yes, don't reply. Much reliance has been made by my learned friend on the order of 1929. Because this has a reference in the Honorable Apex Court judgment also, but all this has been crystallized in one paragraph by the High Court. But before that, can we come to the appeal memo, page 7? These are the issues. As many as 9 issues were framed, because we cannot deviate from the main issues, which is required to be decided by this Honorable Court as well as by the trial court lord. Issue number 1 is, I will just refer to the relevant issues. Whether ZK village migrated from Kyoku village, that is also not that relevant. It is admitted fact. 2, this is relevant. Whether Atsukuku Koki is the traditional boundary between the Kyoku and ZK village. So the issue was to determine the traditional boundary, as I was mentioning in the initial part of my submission. There may be a traditional boundary, but the ownership may be in the beyond the boundary also, if I can purchase. And there are sufficient evidence that Lordship has seen that they are enjoying also beyond the traditional boundary. They are enjoying. We are admitting because they have purchased 40 plots of land. They are in occupation and they are enjoying.
But the boundary set by Hutton is a different boundary.
I'll
not
come
the-
to that. I'll come to that. Now, 3, whether a boundary dispute was taken up between the village by the British in 29 and 25, 35 May. Whether the issue 6, whether the appellant village has been in continuous and peaceful possession and enjoyment of the disputed land. So, and then 8, whether the decision of 13/7/1929 is executable in view of the law of limitation and the law of adverse possession. these are the main issues which has been framed. And kindly come to paragraph 23, page 148 of the appeal memo. Up to this, basing on the issue, the matter reached up to the Supreme Court. The Supreme Court has also directed the trial court to decide on the adverse possession and also the legal value. What is the legal effect of the order? Now, yes, no doubt, the order passed by the learned Additional Deputy Commissioner Judicial has been set aside and quashed. Kindly come to page 136. I have already referred to this
The
page.
findings.
Finding is there, and the next page. Legal effect is also decided here. So these are the two pages which is relevant, 136 to 138. This is the finding. Against this finding, the plaintiff has filed a first appeal, that is FA 9K of 2002. And while deciding that case, in paragraph 23, it has been crystallized, page 148.
That has been read out, I think.
Yes. Paragraph 23.
23.
Just my learned friend has read out this, and I'm relying on this. And kindly come to the last part of the paragraph. J. Chotung, the 10th Deputy Commissioner, they claim, third last line of first paragraph. The claim for adverse possession by the respondent, Kyoku village, deserves a proper determination. So this was the finding. Giving in view of the order passed in 1929 and
You're
1935.
reading from paragraph 23, na?
Yes, para 23, last three lines.
Okay, okay.
The
Yes.
claim for adverse possession by the lordship from the middle of the
Deserves a
paragraph,
proper-
as it is not possible. It is
Yes, it is a
possible
possible
proposition
proposition.
that some villagers of Siki village may have been in possession over some land of Kyoku village, and at the same time, some villager of Kyoku village may have now been in possession over some land of Seki village, which would be at a variance from the boundary contained in the order dated 13/7/1929. See, even though the boundary may have been determined in the order dated 13/7/1929 of J.H. Hotung, the 10th Deputy Commissioner, the claim for adverse possession by the respondent Kyoku village deserves a proper determination. Although it is boundary is given. What about the adverse possession? That is very important. The adverse possession deserves a proper determination. Now, it was to determine how I was enjoying my land, whether I was enjoying my land or not, whether they were also enjoying their land. 40 plots of land, it is on record that they have purchased, we sold it. And they are cultivating that land beyond the traditional boundary. That is evident. We also have land in that area, in the traditional boundary is already there, and we are enjoying that land, that part of the portion. Now, in paragraph 26 of this judgment, this honorable court, the finding says that difficult to determine the claim of adverse possession by the villagers of Kyoku village. That is the finding.
Saying that evidence is not sufficient.
Yes, exactly, Lordship. This is just in direct conflict with the discussion which the same court has held in paragraph 8. Oh, no.
No,
This,
what the court said in para 23.
no.
You-
Paragraph 23,
Court said that it deserves a proper
yes,
determination.
yes,
Then, but however, in para 27, it said that additional evidence may
yes.
have to be taken.
Yes,
Because it is not enough.
yes. Now, thereafter the trial was conducted.
Mm.
Finding in paragraph 26, which the learned trial court has referred to, the finding of this honorable court. He has discussed, but all his finding of the trial court is contrary to his discussion which he had in paragraph 8. In paragraph 8, he has discussed in detail about the enjoyment of the land by the respective parties, by the two villages. And it is an evidence also in the paper book. From page 143, page 43 to 121 of the,
In the paper book.
in the appeal memo.
In the paper book.
All the evidence have been closed. Since he has arrived to a conclusion, the trial court has arrived to a conclusion that there is no evidence on the adverse possession. How we have enjoyed,
Mm.
how they have been enjoyed, there is nothing on record. That's why in order to show from record that we have enclosed in the appeal memo from page 43 to 121. These are all evidence. But all this evidence, just by a stroke of a pen, the learned trial court arrived to a conclusion that there is no evidence. It's very easy to say. Even I can say also. But then such finding and observation
Page
is contrary to
43
the
to-
courts.
Page 43 to 121.
121, all are evidences. Now, my learned friend has again made a submission by referring to paragraph 2 of the judgment.
Mm.
That although opportunity was afforded
Mm.
to the parties, we have opted
Not
not
to-
to go for fresh evidence.
Not to go for additional evidence.
Yes. It is not only we, they have also opted not to go for it because many of the witnesses were no more, already dead. Most of the witnesses from both sides, not only us, but from your side as well. And as the probable word says, dead tells no tales. So they cannot speak. So that was the reason why we did not opted for to go for fresh evidence, number one. Number two, which is very important. Since the order passed by this honorable court says, on the basis of the evidence available on record. So there was enough evidence available on record. What is the necessity to go for a fresh evidence again when it is already there? If it is not there, yes, we could have gone for fresh evidences. And all those evidences he has discussed in paragraph 8 of his judgment.
But
But
again,
in
the.
the
single judge-
conclusion,
Yeah, single
in the
judge said
conclusion,
that
he
the-
has said that there is no evidence to prove. What he has discussed, he is saying that there is no evidence. That means he may have forgotten at the end of the conclusion of the judgment. So that is why we have taken a ground that it is a reverse finding. A finding which is contrary to the records, evidence. Therefore, my submission is let the district judge Dinabutu may be directed to conduct a free trial in terms of strictly in terms of the order passed by this honorable court which was passed on 30/10/2018. And the rulings which my learned friend has just placed before your lordship, I fully admit the principle of law, and all this rulings supports my case because there was sufficient evidence available on records to prove that we have been enjoying the land all along. And they have also admitted about the enjoyment of the land, which has been reflected in the discussion held in paragraph 8 of the judgment, and the evidences which he has reflected as PW and TW, all this are there in the evidence which we have enclosed from page 41 to 121 of the appeal memo.
Your Ladyship, just 1 minute.
Yeah.
We have decided not to go or not to seek for additional evidence, not because that tells no tell, but but because we never made any claim on adverse
Adverse
possession.
possession.
We never made any claims on adverse possession, and there was therefore no necessity for us to leave additional evidence. We made a claim on the basis of title. Title is that is the boundary between the two elements. That this is land. I'm the true owner. Therefore, I need not make a claim and leave additional evidence to support my claim. And my lady, nine issues frame. All validity relating to the validity of the order of 2930 decided in our favor, or that it exists and it has its effect. Only issue that was left alive or said when it was remanded back is that adverse possession.
And the learned court below has decided the case without knowing what is adverse possession.
And the only court which can say that there is material on record is the court higher to this. There is a Supreme Court. Because earlier we have already decided that there's no evidence.
So you're saying that the coordinate court has already said that there is no evidence.
Yes. Unless
Reserve. Yeah, learned counsels for the parties. Orders reserved.
For hearing, item number 7.
Mr. Sharma, I think we'll send this back. Because list of dates also just say from the very beginning, this agreement is between the villagers, the state government and the Assam Rifles, isn't it?
Yes, Lordship.
It is the.
And without hearing the state government,
Yes, that is the.
how can the court
Lordship,
decide?
that can be decided by this honorable court by going through the evidence on record. Because the land in dispute, there is only question is that whether my land and property falls within the 50 acres of land, what has been already allotted.
Without a report of
No,
the state,
no.
how can we know
No,
whether it
the
belongs?
state government will say that this was within that portion, this was
No,
not
Lordship.
within that portion.
Even evidence, even in their written statement, whatever it may be available in the record, it is very clear that that there is no dispute in regards to the 50 acres of land, which has been allotted to the government by the Konkan village to the Assam Rifle. Only dispute is they have encroached another 26.42 acres of land of the Konkan village. My land is falls within the encroached land. Because of that, they are now claiming that that is their land. And factually, my land and property is falls within the encroached land.
See, Mr. Sharma, as
Yes.
far as demarcation and boundary and all are concerned,
Yes, Lordship.
it is always the state government through the revenue department. They send their surveyors and everything. Then the court can always appoint a commission also, and then demarcate and say that this was within that portion, this was within that village boundary, but that they have encroached. So without all that, how the court will come to a conclusion that it was within your land, that it was that your land was encroached and all
It
that?
is not
Lordship,
denied that,
Oh.
it is not denied that
Maybe-
the Assam Rifle, they have encroached some land. But the question is whether the particular land was in the encroached land or in the demarcated land. That has to be surveyed. That has to be
That's what I'm
approved.
saying.
Yes,
Some
without that,
survey, without some sort of survey.
There is a survey report
Then how-
even in the record, Lordship. I will refer it in the time.
but it does not say whether
There is a report, Lordship, clear report. That can be analysis for the evidence only, Lordship.
Okay, anyway, let's hear them.
Lordship.
Yes. What is your main ground, Younger?
my main ground is that the land was handed over to me by the state government.
Where? Page 8.
Page 4 for my appeal. Roman 2. My Lordship. The Konkan village agreed to give 50 acres of land to the Assam Rifles, and accordingly, an agreement that so and so was duly entered between the Konkan village, the state government, and the Assam Rifle for acquisition of 50 acres of land. Whereas the land under the occupation of the petitioner, Assam Rifles, was leased out to the Assam Rifle in the year 1960. And subsequently, in the year 1978, an agreement dated 27/10/78 was executed between the Konkan village and the Assam Rifle in the presence of district administration. The said plot of land under the occupation of Assam Rifle measuring 50 acres of land was acquired by way of the absolute purchase at a rate of 2,000 rupees only per acre, and in addition to compensation of rupees 1 lakh was also paid to the landowners by the Assam Rifles. So in all the transactions, this district administration was also a party in all the agreements that has been entered into between the Konkan village. And the alleged land permit was issued by the district administration. So that is also in dispute. So they should have been made a party. And without making a party, how can we decide that whether that particular plot of land belongs to the land that was donated to us, was given to us, or whether it falls outside? Well, without the proper survey from the district administration, how can this matter can be decided? So on this ground alone, for non-joinder necessary parties, the order passed, judgment and decree passed by the Lada District Court is liable with the cost.
But in your grounds, you have not said anything about that. Just come to your grounds, page 8.
Worship in my grounds at 8, page 8,
Yes.
Roman 7, 8. For that, the declaration should have been dismissed for non-joinder of necessary party. That is the state government, as the land was acquired by the state government and leased out to the Assam Rifles. So the land was first acquired by the state government, the land of the Konkan village, and was handed over to the Assam Rifles.
That is your main ground.
That is my main problem. And even the highest authority of the village, the Ankh, the village chief, they have deposed on our behalf. But the statement issued by the Ankh as well as the village chief, the head GB, has not been taken into account by the district judge. They are the authority among the village lordship, the Ankh, the village chief, and the head GB. They all dispose on in behalf of the Assam Rifle, but has never been considered by the district judge.
Let us see the impugn order. Page 23.
Yes, sir.
So your prayer in the suit was compensation, isn't it? Your prayer in the suit.
No, my prayer is for
Appropriate compensation from the against the encroach.
no, I am not claiming any compensation. I am claiming only right and title over my own
Over
property.
that land.
Yes. No.
Because in the judgment, in the beginning, it says against the illegal encroachment of 26.42 acres of land by the defendants, the Kongan Village Authority submitted representations before the DC Mon and also the ADC Naginmora, bring for appropriate compensation from the defendants against the encroached 26.42 acres of land. It may be noted that negotiation for payment of compensation between the parties is under consideration.
That is
but yet
only in regards to the encroached land. Apart from the 50 acres of land, Assam appellant encroached another 26.42 acres of land. My land and property falls within the 26.42 acres of land. However, since they are illegally encroached the village land, villagers now claiming compensation against the 26.42 acres of land, for which negotiation is going on. That is different issue, Lordship.
Okay.
Yes, Lordship.
Now, the only question is
So you
whether
are a
land.
private individual who is
Yes,
claiming
yes,
your land is within
yes.
this 26.42.
Lordship, Lordship.
Now the only question is whether that land will situated at the 50 acres of land or the land that has been encroached. And without verification from the state government by the land revenue officer, how can the court just say that without determining where is the site. How can a court just says that that land belongs to the petitioner without proper verification? It is not denied that some portion of land has been encroached by the Assam Rifles.
Finally, what did the court say?
That's page 39 is a degree.
Mr. Sharma, yeah.
Yes, sir. Lordship, I have
Are you-
prepared a gist, a forward copy.
Hmm.
May it please your lordship. The fact of the case is that the present respondent appellant in the appeal belongs to a Naga community of Konyak tribes who having their own customs and traditions in regards to administration of justice as well as administration of land and properties within the jurisdiction of the respective village and clan or within the jurisdiction of respective village council lordship. The custom, uses, and such practices are well acceptable among the Naga society at large, the state of Nagaland, as well as even in the court of law lordship. Prior to 1974 lordship, Kongon village and its villagers, including the plaintiff's father, late Henze Konyak, were occupying a large portion of land as per their traditional custom, practice, and uses prevailing among the Konyak community, and thereby become the absolute owner of the land. Under initiative of the government of Nagaland, 50 acres of land was requisitioned from Kongon village for construction of temporary headquarters of 13 Assam Rifles at Naginimara, and for the purpose aforesaid, the Gauhati and Ang, by representing the Kongon village, come to an agreement on 19th day of November 1960, that is Exhibit P2, page number 7 of LCR lordship. There is an agreement, initial agreement. It is already marked and exhibited as P2, and it is available in the LCR, page number 7 of LCR.
LCS here, no?
Page number 7, lordship, exhibit P2.
No, page 1A to 39A is the order sheet.
That is order sheet.
Order
Thereafter, Lordship.
sheet. Then
Apart from the order sheet, there is a,
deposition is
yes.
page 52. Starts from 52. Deposition of Chintik Konyak.
No, Lordship. Exhibit P2
Hmm.
is the original agreement which is found to be available in the LCR page number 7.
No. It's not telling.
No, Lordship, it is there. May I assist your Lordship?
Let's because here the paging is again rearranged. No,
No, there is a two sets of original documents, LCR Lordship. The first one is appeared to be clumsy because of that under direction of this honorable court, they have sent. This is the order sheet. Okay. So this is the original agreement which has been signed and executed by the village authority as well as the Assam Rifle on behest of the government of Nagaland. Lordship, through the said agreement, only 50 acres of land was given to the appellant Assam Rifles with a restrictive condition number 2, 3 that no further condition number 2, subcolumn 3, Lordship, that no further requisition of land on the west side of the road will be accepted by us in future. Apart from the 50 acres of land, there is a restrictive covenant is that no further land can be encroached by anybody. Lordship, in the instant case, the respondent plaintiff have no dispute in regards to the holding of 50 acres of land by the appellant. It is an admitted fact that in addition to the 50 acres of land, the appellant encroached another 26.42 acres of land belonging to the Kongon village, and there is a clear admission of the appellant in their deposition in affidavit filed in the court below. Deposition in affidavit, Lordship, DW1 in page number 3 and 4, LCR page number 66. There is a clear admission, Lordship. LCR page number 66, Lordship. Deposition in affidavit of DW1. Here, Lordship, deposition in affidavit, the DW2 in page number 3 and 4, LCR page number 79. Deposition in affidavit of DW3 in page number, paragraph 3, LCR page number 92, Lordship. Deposition in affidavit of DW4 in paragraph 3, LCR page number 96, Lordship. Deposition in affidavit of DW5 in paragraph 3, LCR page number 94. To ascertain the enclosed area of land by the appellant as directed by the Director of Land Records, by order dated so-and-so, 27 October 27, the technical staff under LRSO Mon surveyed the land and find out that 6th Assam Rifle camp occupying an excess land of 26 acres. Accordingly, the land records and survey officer Mon submitted his survey report to the director, exhibit P5, page number 27 of LCR, Lordship. That is the report. Page number 21 of LCR, the report is there, Lordship. Page number 21. which we have exhibit as P5, Lordship. For necessary compensation in time to time, representations are filed by the Congon Village Authority with the appellant. That is exhibit P3 in LCR page number 41, Lordship. There is a representation even filed on various occasions from the Congon Village for seeking compensation against the encroached land. It is an admitted fact, Lordship. And exhibit P4 in LCR page number 42, and this is the admitted fact of the appellant witnesses before the court below in regards to the negotiation for payment of compensation against the encroached land, which is corroborated by the letter dated so-and-so, reference number so-and-so, dated 24th February 2014, LCR page number 74, Lordship. Lordship, it is also categorically stated by the plaintiff witness as well as the defendant witness in their examination that encroached 26.42 acres of land is clearly bifurcated by a 30 feet breadth road as a boundary between 50 acres of land holding by the appellant, whereupon the appellant even demarcated an erected boundary. The land in dispute falls well within the west side of the rear corner of the road, which is clearly bifurcated by 30 feet breadth road connecting from Naginimara Waxing Road towards Dikhu River in one side, and the other side is bounded by Naginimara Waxing Road and also the Dikhu River. As agreed in the original agreement executed on 19/11/60, as per the restrictive condition number 2, Roman 3, specifically impose bar that the appellant Assam Rifle cannot acquire and cross any land in the west side of the road in future. That is the clear restrictive covenant in the lease, that agreement. Prior to the year 1978, in the rear corner of the boundary road of the, by constructing a patka house, the respondent plaintiff running a canteen for his means of livelihood, Lordship. The dispute arises only after encroachment of 26.42 acres of land by the appellant, whereupon prior to the year 1978, the respondent plaintiff earning his livelihood through a canteen, Lordship. The dispute arises only in the year 2013. Since 1978, there is no dispute till 2013, Lordship. Only in
You were
2000
running the canteen from 78.
Yes, Lordship. My father was running there. Thereafter, it has been comes to me, Lordship. The dispute arises only in the year 2013, while the appellant illegally and arbitrarily by issuing 2 letters bearing reference number so-and-so dated 26 July 13, exhibit P7, LCR page number 9, Lordship. And the letter reference number so-and-so dated 4/8/13, exhibit P8, LCR page number 10, Lordship, whereby directed the respondent plaintiff to forthwith vacate the land and building from his land. Since 1978 till 4/8/13, the possession of the respondent plaintiff in his own land is unblemished, uninterrupted, and peaceful. The dispute arises due to encroachment of 26.42 acres of land by the appellant, Lordship. Before that, there is no dispute at all. My land, my right, my title, my possession are peaceful and without interruption anybody's. Lordship, upon receipt of 2 illegal and arbitrary letters from the appellant, the plaintiff apprehending of forceful eviction and to restrain the appellant has filed a civil suit being numbered as civil suit number 1 of 13 before the district judge Mon, Nagaland. The respondent plaintiff has examined 3 witnesses and the appellant respondent examined 5 witnesses on their behalf. After completion of the proceeding and being satisfied with the material evidence available in record, the learned district judge reaffirmed the right and title of the respondent plaintiff over the land and decreed the suit in favor of the plaintiff by its decree dated 2011-18 and granted perpetual injunction by restraining the appellant and their workers and agents for dispossessing and evicting the plaintiff from the suit land and building. Also impose cost of rupees 10,000 against the defendant, Lordship. The finding of the court below is entirely based on material evidence available of both the parties as in the record. The appeal filed by the appellant have no merit and is liable to be dismissed with compensatory cost. Lordship, the appellant has raised some grounds of appeal. My submission against the respective now ground is that submission against ground number 2 and 3, Lordship. The allegation is the land dispute is false within the boundary of the appellant's land. Also, the court below failed to consider the evidence of the appellant, Lordship. Against the allegation, the respondent plaintiff submits that the land belonging to the respondent plaintiff is never falls within the boundary of 50 acres of land, whereas the land and building is falls within 26.42 acres of land, which has been subsequently encroached by the appellant, Lordship. In examination of the plaintiff, Sri H. Sintik Koinak, PW1, that is LCR page number 52, Lordship, and the relevant LCR page number 54 and 55. In paragraph 2, the deposition in affidavit categorically stated that the petitioner as well as his father offered only 50 acres of land to the defendant by an agreement dated 19/11/60, where there are also another 26 acres of land belonging to the Gangon village, which clearly demarcated and bifurcated by a road about 30 feet breadth connecting from Naginimara Waxing Mon Road towards Dikhu River in one side, and the other side demarcated by the Naginimara Waxing Mon Road and the Dikhu River, whereupon in the rear corner of the boundary, Lordship, by the said 30 feet breadth road facing towards the Naginimara Waxing Mon Road, by constructing a Pakka house, I am running the canteen prior to the year 1978, Lordship. That is the admitted fact, Lordship. The defendant forcefully and illegally encroached the above 26 acres of land belonging to the Gangon village as well as to us before few years by taking advantage of the innocent villagers, and because of their encroachment, my land and property are in dispute, which is claimed to be the land of the defendant encroachers. On various occasions, the Gangon village authority requesting the defendant to vacate the land. However, the mighty defendant, without caring the request of the villagers, continuing their encroachment till death. As far as my knowledge is concerned, the Gangon village authority on various occasions submitted representation even before the deputy commissioner and additional deputy commissioner for paying compensation upon the defendant against their illegal encroachment of 26 acres of land. Further, the land records and survey officer Mon, by conducting a physical verification and measurement ascertaining that the defendant encroaching 26 acres of land belonging to the Gangon village apart from 50 acres of land given out earlier, and accordingly submitted detailed survey report with the director land records and survey by reference number so-and-so, dated so-and-so, February 2012, and forwarded similar copy even to the defendant. I am running the canteen prior to the year 1978 with continuous uninterrupted peaceful possession. My peaceful possession on my land continuous and without any disturbance from the defendant since 1978 till 5th July 2000. 13. To my utter surprise, defendant served to impugn letter, reference number so-and-so, dated so-and-so, July 13, and the impugn letter, reference number so-and-so, dated 4/8/13, whereby the defendant directed me to vacate my land and property forthwith, failure threatened to force eviction. Again, on 1st October 2013, one senior officer of the defendant called me into their office and by showing me a letter from distance, ordered me with dire consequence to vacate my land and property and surrender to them. However, the contents of the said letter were never allowed to me to verify. This is the statement of the PW1. The PW1, now it is the interesting. The PW1 is also cross-examined by the counsel for the respondent appellant, LCR page number 97, Lordship. The relevant page number 98 and 99. To reply the cross-examination, the PW1 stated that the wet canteen is outside the 50 acres of land. The wet canteen is constructed by my father prior to 1978. Exhibit P5 is land record and survey report of the LRSO, Mon, page number 21 of LCR. That is on LCR. It is correct to say that 26 acres of land is enclosed by the Assam Rifle. Measurement was taken by the Land Record Department. As per the survey report, my land and canteen is outside the boundary of 50 acres of land. Lordship, there is no rebuttal evidence at all, even in the cross-examination, that the land and property of the present respondent plaintiff is falls within the 50 acres of land. There is no even suggestion also. There is no cross-examination on the point. Lordship. In examination of PW2, very interesting. Siri K. Ane Koinak, LCR page number 57, Lordship, stated that I know the plaintiff and his father from my childhood, who belongs to the Koinak tribes. Prior to 1974, the Kongon village and its villagers, including the plaintiff father late Hamze Koinak, were occupying a large portion of land at Naginimara as per traditional custom, practice, and uses prevailing among the Koinak community. It is a fact that, as requested by the respondent through the Deputy Commissioner, Mon, the Kongon Village Authority and the villagers given out 50 acres of land in the year 1960 by executing an agreement. Whereupon, in the terms of the agreement, the defendant ought to have constructed their only temporary office. Even in the agreement, it was clear, categorically stated that the land was 50 acres of land was allotted to the Assam Rifles only for construction of their temporary office. But they have now constructed multi-stories building over the land. Apart from 50 acres of land given out to the defendant, there are another 26 acres of land belonging to the Kongon village. The 26 acres of land is already clearly demarcated and bifurcated by a road about 30 feet breadth connecting from the Naginimara Waxing Mon Road towards Dikhu River in one side, and the other side demarcated by the Naginimara Waxing Mon Road and the Dikhu River. Whereupon, in the rear corner of the boundary bifurcated by say 30 feet breadth road and facing towards the Naginimara Waxing Mon Road by constructing Pakka house, the plaintiff running the canteen prior to the year 1978. The defendants forcefully and illegally encroached the above said 26 acres of land belonging to the Kongon village as well as the plaintiff before few years by taking advantage of the innocent villagers, and because of their encroachment, the plaintiff land and property are in dispute, which is now claimed to be the land of the defendant encroachers. As far as my knowledge is concerned, the Kongon Village Authority requesting the defendant to vacate the encroached land on several occasions, even submitted representations with the district administration for seeking appropriate compensation from the defendant against their illegal encroachment. As I learned, now the defendants are negotiating Kongon Village Council Authority as well as with the other organization of the area for payment of compensation against 26 acres of encroached land. Unless the defendant encroaching the 26 acres of land, there was no dispute in regards to the land and property of the plaintiff. Prior to 1978 till 2013, as I know, there was no dispute or disturbance from the defendant against the peaceful, continuous, and uninterrupted possession of the plaintiff. Lordship, the statement of the PW2 is entirely corroborated with the statement of the PW1. And my Lordship, interestingly, it will be appear again in the cross-examination.
What happened in the cross?
Cross-examination. The PW2 also cross-examined by the counsel for the respondent appellant, LCR page number 100 and 101. To reply the cross-examination of the counsel stated that the canteen was initially running by the father of the Sintik Koinak before 1978. The canteen in dispute is not within the boundary of 50 acres of land. It is correct to say that 26 acres of land is connected and crossed by the Assam Rifle, whereupon the canteen in dispute is situated. That is the clear, unrebutable evidence of the PW2, Lordship. Lordship, in examination of PW3,
PW2, who is PW2?
PW2 is he has deposed on behalf of
No. What I mean is, who is he in the village?
He is a villager.
Oh, he's a villager.
He is a villager, Kongon villager, Lordship. Again, in examination of PW3, C. Singyong Koinak, LCR page number 62 and 63, stated that I know the plaintiff and his father from my childhood who belongs to the Kongon Koinak tribe. Prior to 1974, the Kongon village and its villagers, including the plaintiff father late Hamzi Koinak, were occupying a large portion of land as Naginimara, as per traditional custom, practice, and uses prevailing upon the Koinak village. It is a fact that, as requested by the respondent, through the Deputy Commissioner Mon, the Kongon Village Authority and the villagers given out 50 acres of land in the year 1960 by executing an agreement, whereupon, in the terms and agreement of the defendant, ought to have constructed only their temporary office. Apart from 50 acres of land, the defendant encroached another 26 acres of land belonging to the Kongon village. The 26 acres of land is clearly demarcated and bifurcated by road about 30 feet breadth connecting from the Naginimara Waxing Mon Road towards Diku River in one side and the other side demarcated by Naginimara Waxing Mon Road and the Diku River, whereupon in the rear corner of the boundary bifurcated by 30 feet breadth road facing towards the Naginimara Waxing Mon Road by constructing a pakka house, the plaintiff running the canteen prior to the year 1978. The defendants forcefully and illegally encroached the above said 26 acres of land belonging to the Kongon village before few years by taking advantage of the innocent villagers, and because of their encroachment, the plaintiff and land and property are in dispute, which is now claimed to be the land of the defendant encroacher. As per my knowledge is concerned, the Kongon Village Authority requesting the defendant to vacate the encroached land on several occasions, even submitted representation with the district administration to seeking appropriate compensation from the defendant against their illegal encroachment. As I learned, now the defendants are negotiating with the Kongon Village Council Authority as well as with the other organization of the area for payment of compensation against 26 acres of encroached land. Unless the defendant encroaching the 26 acres of land, there was no dispute in regards to the land and property of the plaintiff. Prior to 1978 till 2013, as I know, there was no dispute or disturbance from the defendant against the peaceful, continuous, and uninterrupted possession of the plaintiff. The PW2 was cross-examined. To reply the cross-examination of the counsel of the appellant, the PW3 stated that, LCR page number 101 and 103, Lordship. It is correct to say that initially the wet canteen was running by father of Siri H. Sintik Koinak outside the boundary of 50 acres of land. I reaffirm that the canteen in dispute is outside the boundary of 50 acres of land Kongon village only given 50 acres of land to the Assam Rifle. Beyond that, the Assam Rifle encroached 26 acres of land whereupon plaintiff canteen is there running prior to 1978, Lordship. Lordship, the statement of PW 1, 2, and 3 remain unshaken and consistent in all truth. All the plaintiff witnesses without any ambiguity establish that the plaintiff canteen land and building are false well within 26 acres of land which has been enclosed by the plaintiff. The alleged disputed land is never falls within the boundary of 50 acres of land. Lordship, in the court below, the defendant appellant has filed a common written statement on behalf of the defendant number 1, 2, 3, 4, 5, and 6. Whereas under Order 8 of Code of Civil Procedure, each defendant is required to file written statement separately. How the appellant file common written statement for the all defendants in the court below? Lordship, this means that each defendant must individually respond to the allegations made in the plaintiff, Lordship. However, if multiple defendants have closely aligned defense and interest, they may file a common written statement which must be signed by the defendants. Otherwise, the written statement filed by one defendant does not bind other defendants, Lordship. The common written statement, LCR page number 26 and 30, Lordship may kindly peruse it. Page number 26 and 30, Lordship. They are common written statement, Lordship. Filed by the defendant number 5 did not state about detailed information about his locus standi as well as his authority to file the common WS on behalf of the other defendants, nor the WS verified in a manner as required by Order 4, Rule 15(4) CPC, which is to be supported by an affidavit, and similar casualty is also appeared in the WS filed after RICA's amendment petition, LCR page number 22 to 25, Lordship. It is a so-called vague written statement, Lordship. It has no evidentiary value.
Anyway, the order is in your favor.
Yes, Lordship.
Ultimately, the order is given in your
Yes,
favor.
because of that order is in my favor.
Okay.
Yes, Lordship. May I continue?
Yes, yes.
The appellant altogether examined 5 witnesses. In the course of proceeding, not a single document marked and exhibited by the defendant's witness to substantiate their claim. Very interesting, Lordship. They have examined 5, 6 witnesses, not a single document marked and exhibited in the court below as their witness. How it is, Lordship? How they can claim here that this is their land? Lordship, Evidence Act 1872, Section 61. Here, reference cases National Insurance Company Limited, Hasina Begum, Mustafa and others, GLT, 2018 GLT, page 261, para 18. Unless any documents has been marked and exhibit, it is not open for the appellate court to read the contents of such unexhibited documents. Mere filing of photocopies of documents along with the deposition in affidavit is not enough to consider such documents as a part of evidence unless such documents marked and exhibited before the court in accordance with law, Lordship. Lordship, in examination of DW1, now I'm going to discuss about the DWs. In examination of DW1, Major SD Sunar, LCR page number 65 to 67, Lordship. He is not a party respondent in the original plaint. He is not a party respondent. Into the original suit, who has filed deposition in affidavit and deposed on behalf of the appellant without any authority. Even in the deposition in affidavit DW1, nowhere stated that the DW1 is authorized or competent to sworn the deposition in affidavits on behalf of the appellant respondent in the original suit. Factually, the DW1 is not a competent witness, and on the basis of his evidence, the instant appeal cannot be decided. In cross-examination, Lordship, the DW1 LCR page number 104 and 110 fairly admitted that I do not have any power of attorney or authorization letter to produce before this court to prove that I have authorized to depose on behalf of the defendant number 126. It is correct to say that I am not a defendant in the instant suit. It is correct to say that I do not have any documentary evidence to prove that there is any dispute between the plaintiff and the defendant since 1978 to 2013. It is correct to say that the plaintiff holding the land and running a civil canteen prior to my born. I have no knowledge why Assam Rifle Authority constructed permanent structure over the land dispute. The fact that the agreement, it was conditioned only for creation of temporary structure. It is not mentioned in the agreement that both sides of land, Naginimara Waxing Mon Road falls within 50 acres of land. I admit the suggestion that the agreement dated 1911-60 in condition number 3, it is categorically mentioned that no further requisition of land on the west side of the road will be accepted by us, despite the fact how Assam Rifle encroached the west side of the land of the Naginimara Waxing Mon Road. I have no knowledge. It is correct to say that plaintiff land falls within the west side of the Naginimara Road, Lordship. This is even admitted by the DW1 that the plaintiff land falls beyond the boundary of the 50 acres of land. It is correct to say that other 50 acres of land of Assam Rifle Authority encroach another 26.42 acres of land of the Kangon village, for which Kangon village authority demanding compensation against us, which is now under negotiation. It is correct to say that the plaintiff, by constructing Paka house running his civil canteen, it is fact that by constructing a Paka house in the year 1978, the plaintiff running his civil canteen and enjoying all interest and profit, and I have no knowledge whether Assam Rifle Department raised any objection for construction of permanent structure over the land in dispute. It is true and correct that we have not filed any original documents before this court for verification, nor even any documents filed certified to be true, Lordship. This is the admission. It is fact that we have not obtained any permission from the Honorable Court to produce photocopy of documents as a part of evidence. I have no knowledge about the clarification letter dated so-and-so, dated Naginimara, the 4th April 23, clarified that the said permit issued by the Badad and ADC HS Futon is true and correct, though copy of the same served to us. I have no idea whether temporary land permit issued by plaintiff for connection competent authority only to facilitate the plaintiff to get electricity renewal connection, Lordship. That is there. What is now stated by the appellant that he has filed some land permit documents. That is in fact that was obtained only to get the electricity connection, renewal electricity connection. License, trade license after commission of Naginimara Town Administration. That was because of required for after construction, after
Constructing the road.
commission of the Naginimara Township. It is correct to say that I have no knowledge whether plaintiff person and bill holding continuous, peaceful and uninterrupted since 1978 to 2013, and I have no knowledge whether the plaintiff enjoying adverse possession under land. It is correct to say that plaintiff land is bifurcated by, it is correct to say that, Lordship, the plaintiff land is bifurcated by 30 feet breadth road connecting with Naginimara Waxing Mon Road towards Diku River and other side bounded by Naginimara Waxing Road and Diku River. Now, Lordship, DW2. Mr. J.H. Bhuya is the Subedar Building and Road, LCR page number 78 to 80 page, who is not impleaded as a party respondent into the original suit, who has filed deposition in affidavit and deposed on behalf of the appellant without authority. Even in the deposition in affidavit, DW2 nowhere stated that the DW2 is authorized or competent to sworn the deposition in affidavit on behalf of the appellant respondent in the original suit. Actually, the DWT is not a competent witness, and on the basis of which evidence in the instant appeal cannot be decided. In cross-examination, Lordship, the DW2, LCR page number 111, 113, Lordship, categorically admitted that it is true and fact that I am not authorized by the defendant number 126 to depose on behalf of them before this court, nor even I am impleaded as a respondent defendant into the suit. It is true and a fact that I have no locus standi to depose on behalf of the defendant number 126 before this court. This is, he admitted himself, he has no locus standi to depose before the court. It is true and correct that since 1978 till July 13, the plaintiff possession over the land was peaceful, and the plaintiff running the canteen there, and the dispute arise in July 13, while our department issued a letter asking the plaintiff to vacate the land. It is true and fact that the condition number 3 of the agreement, LCR page number 7, executed on 1160, it is categorically mentioned that no future requisition of land on the west side of the road will be accepted by us in future, despite the fact I have stated in deposition in affidavit both sides of the land of Naginimara Waxing Mod Road fall within 50 acres of land. It is correct to say that the land admitted, an admitted fact that the plaintiff land falls on the west side of the Naginimara Waxing Road. It is a fact that whatever documents we have filed are not certified to be true. It is correct to say that apart from 50 acres of land, our department encroached another 26.42 acres of land belonging to the Kongon village, for which Kongon village authority demanding compensation. From the clear admission of DW2, it is made clear that the DW2 is a stranger who has no locus standi to depose on behalf of the appellant. The DWT, he is the important person, Ang of the Kongon village. His statement is very important. LCR page number 91 and 92, Lordship. In his cross-examination, LCR page number 114 and 15 stated that it is correct to say that as per agreement dated 1911-60, our Kongon village authority handed over only 50 acres of land to the defendant Assam Rifle. Thereafter, the defendant Assam Rifle occupied and encroached another 26.42 acres of land of Kongon village. As such, our Kongon village demanding compensation from the Assam Rifle for their illegal occupation, and as such, negotiation is going on regarding payment of compensation against 26.42 acres of the land. It is correct to say that the land in dispute, bifurcated by 30 feet breadth road connecting from Naginimara Waxing Road towards Diku River, and the other side bounded by Naginimara Waxing Road and by Diku River, and the beyond 30 feet road, Assam Rifle erected fencing by showing their possession. There is a clear demarcation, Lordship, between my land falls within 26.42 acres of land and the 50 acres of land what is already given to them. It is true and fact that agreement executed on 1911-60 in condition number 3, LCR page number 7, it is stated that no further requisition of land on the west side of the road will be accepted by us in future. It is fact and true that the land holding by the plaintiff falls on the west side of the Naginimara Road, Lordship. This is a clear finding. Lordship, the DW4, Mr. Longmi Head GB. His deposition is another important. LCR page number 95 and 96, Lordship. In cross-examination, LCR page number 116 and 117 stated that it is correct to say that initially, as per agreement, only 50 acres of land given to the Assam Rifle without measurement, and thereafter Assam Rifle without any permission from the Kongon Village Authority occupied and crossed 26.42 acres of land, for which our Kongon Village Authority demanding compensation, and there is a negotiation with the Assam Rifles for payment of compensation of rupees 3 lakhs per acre. It is true and fact that the agreement dated 19/11/16 is condition number 3. We have agreed that there will not be further requisition of west side of land of Naginimara Waxing Road. It is true and fact that the land holding by the plaintiff falls on the west side of Naginimara Waxing Road. These are the village authority, who are the supreme authority of the Kongon Village, Lordship. In examination of DW5.
DW4 is head GB.
Yes, Lordship.
He has said that as per the agreement, 50
Yes.
acres of land was given to the Assam Rifle
Lordship.
without measurement.
Without measurement.
Without
But
measurement.
the fact is that though there is a no measurement, but plaintiff land falls within the 26.42 acres of land, which has been encroached by the Assam Rifle. Lordship, in examination of DW5, see Manglong K, LCR page number 93 to 97 or 94, who is a chairman of Kongon Village. In his cross-examination, LCR page number 118 and 19 categorically stated that it is correct to say that apart from 50 acres of land, Assam Rifle encroached another 26.42 acres of land of Kongon Village. As such, Kongon Village demanding compensation from the Assam Rifle, and negotiation is going on for payment of necessary compensation. It is true and correct that the land holding by the plaintiff is bifurcated by 30 feet breadth road connecting from Naginimara Waxing Road towards Dikhu River in one side, and the other side is covered by Naginimara Waxing Road. It is also there here to be mentioned that Assam Rifle, besides 30 feet road towards the Dikhu River, erected their fences showing their boundary, Lordship. It is correct to say that the agreement dated 19/11/60 in condition number 3, LCR page number 7, it is categorically stated that no further requisition of land on the west side of Naginimara Waxing Road will be accepted by us in future. It is a fact and true that the land holding by the plaintiff falls within the west side of the Naginimara Waxing Road, Lordship. The cross-examination and the reply of DW3, 4, 5 are very vital for determination of point of controversy, Lordship. In their examination, it is made crystal clear that the properties of the respondent plaintiff is never falls within the boundary of 50 acres of land, where from the appellant illegally and arbitrarily is trying to evict the plaintiff from his own land. Under the circumstances, the learned court below decreed the suit in favor of the plaintiff, and on the basis of the instant appeal, no interference of this honorable court, and as such, the appeal is liable to be dismissed with cause, Lordship. Lordship, the ground number 4, 5, and 6, allegation is that the plaintiff defraud the court to obtain the judgment. Absolutely a wild allegation of the appellant without legs to stand under test of judicial scrutiny, Lordship. The appellant is an intruder who forcefully and illegally encroached the land of the village, now claiming their legal right over the encroached land. Ground number 6, Lordship.
7.
7, Lordship. The allegation is that the provision of Section 80 is not complied with. The allegation of the appellant is totally perverse and false. To file the suit in the court below, considering the urgency of the difficulty of the plaintiff by order dated 4/10/13 LCR page number 40A, the learned judge allowed the plaintiff to file the suit without service of notice as required by Section 80 CPC. The counsel for the appellant later on filed the objection against the maintainability of the suit due to lack of non-service of notice to the defendant as required by Section 80 of CPC. After hearing of the counsel by order dated 6/6/14, the learned court below passed the following order. LCR page number 5A. The counsel for the order dated 6/6/14 order. The counsel for the plaintiff Sri B.N. Sharma and Mr. Imtiu Opang present. Also counsel for the Union of India Sri Gauhati present. The counsel for the defendant has filed 2 petitions for seeking aside of the order dated 4/10/13 passed under order 39 Rule 1 and 2 CPC, and also another petition for dismissal of the main suit due to non-service of notice as required by Section 80. The counsel
Counsel for the
The counsel for the defendant further submit that both the petition file is not pressed now, as the court by order dated 4th and 13 has granted liberty to the plaintiff under Section 82 of CPC to file the suit, considering the urgency and probable hardship of the plaintiff. Heard the counsel and satisfied. As prayed by the learned counsel, both the petitions are dismissed and not pressed. Fixing 8/8/14 for written statement. Meanwhile, both the parties to the proceeding are hereby directed not to carry out any developmental work, including any structure on the disputed land, until disposal of the suit. Lordship. As such, allegations raised by the appellant have no value in the eye of law. Lordship. Now the submission is, allegation is that state not made party. Lordship. There is no claim against the state government as such. In defense, the the present case is disposed of. In Kosturi versus Manuel and others 2005-6 SCC 733, part number 13. The Honorable Court held from the aforesaid discussion, it is recalled that necessary parties are those persons in whose absence no decree can be passed by the court, or that there must be a right to some relief against some party in respect of the controversy involved in the proceeding, and proper parties are those whose presence before the court would be necessary in order to enable the court effectually complete to adjudicate upon the settled all the questions involved in the suit, although no relief is sought as claim against the such person. In Dev Mitra Bharma versus Dharmadev Bharma 2007 3 GLT, page number 191. Relevant page number, Lordship, 6, 7, 8, and 10. Relevant page number, paragraph 6, 7, 8, and 10.
What about this Kasturi versus Yam Perumal?
2005 6 SCC 733 para 13. In the CLT, Lordship, page number 191, relevant para 6, 7, 8, and 10, Lordship. In para 6, Lordship, in a civil suit, one can never overlook the legal position that the plaintiff is the dominus litis and that he cannot be compelled to sue a person against whom he does not claim any relief, Lordship. I have no claim at all against the government, Lordship. I am stick my claim only against the 26.42 acres of land, which has been encroached by the Assam Rifle. There is no dispute between the parties in regards to the 50 acres of land given to the appellant under initiative of the government, and as such, the government is not a necessary party. Lordship, in this case, though at the time of framing of issue, no issues has been framed in the court below regarding necessary party or unnecessary party. There is no suggestion as such from the opposite party in the court below. Normally, before framing of issues, at the time of framing of issues, court always heard the parties for determination of point of dispute. There is no dispute at all in regards to the dispute, necessary party and others. As such, no issues has been framed. When there is no issues framed, why court below shall discuss the matter? So these are my all submission, Lordship. And Lordship, this court
So you're
is,
saying that this is a new issue which is raised?
yes, no issues framed at all in the court below. It is a new plea. It is a new plea now. If they were aggrieved, then they have to submit before the court below to frame the issue. That was not done. Lordship, this is an appellate court under section 96 of the CPC. This court has ample power to scrutinize the all evidence in the court below as well as like original court, which has been referred from the 2003 5 SCC page 89. Lordship. This is by all submissions, Your Lordship, and under the circumstances, the appeal is liable to be dismissed with compensatory cost, whereby the appellant is illegally trying to evict me from my own land and property, which shall not be allowed by this honorable court.
2003 5 SCC 89 para
Lordship.
11 para.
Lordship, I have not mentioned the para.
Because I'm not going to read the
2003
whole
5
judgment.
SCC 89 page. The power of first appellate court.
No,
Appellate
that-
court ought to have go
That,
with their evidence.
that
ethic
is
like,
not disputed.
Yes,
but
Lordship.
still.
Yes, Lordship. Yes, Lordship. No documents marked and exhibited in the court below. No cross-examination done on that part. Now they were saying that this is their land. Every evidence, even their own witnesses, DW 1, 2, 3, 4, 5, all are asserting, confirm that my land is falls within the 26.42 acres of land, which is not comes within the 50 acres of land, and my land and building not falls within the 50 acres of land. This is my humble submission before your lordship.
Any reply?
Give a short reply, Lordship. With regard to the common written statement, Lordship. All the respondents, they are the agencies of the Ministry of Home Affairs. So it is not necessary that all the respondents, they have to file a separate written statement. Once the officer is authorized by the Ministry of Home Affairs, because they are the agency of the Home Affairs, one common written statement will survive.
There is no authorization as such. There is no authorization
In my
as
written
such.
statement, it said I've been duly authorized by the respondents. In my written statement, Lordship, I have placed that I so and so have been duly authorized by respondents to file
No,
this.
their lordship. It is not their lordship. In the written statement, even in the written statement is not verified in the manner as required by CPC. Not even any statement has been given in the written statement that the defendant number 1 is duly authorized by the other defendant. It will be crystal clear in the written statement, Lordship.
Let's see. Statement that I've received a copy of the plaint. I'm going to the same.
Page 26 to 34 or 30, I'll share. In LCR, page number 26 to 30. Nothing has been disclosed.
You have not stated anywhere that. it
Yes,
is
Lordship.
authorized. This means we-
This it to be stated in the petition that I am being duly authorized by the respondent dependent number so and so, so and so. I am competent to do this. Nothing has been there. Even in the course of proceeding, he has not filed any authorization that he is duly authorized by the other defendant or by the Assam Rifle to depose on their behalf. Lordship, this is my submission, Lordship.
I have gone through, Mr. Young, but it's not there. The statement is not there.
The at the time of filing of the petition,
Hmm.
it was because the Assam Rifles, they keep on changing every 3 years.
Hmm.
They get transferred, the new covenant come, and when the Assam Rifle was established in the year 1960,
Hmm.
it was the Assam Rifle Lordship. After that, every 3 years, the Assam Rifle, they keep
No,
on
no, no.
changing.
We're
And by the
talking
time-
about
by
the
the time-
deponent who swore the affidavit.
By the time
WS.
by the time the WS was filed,
Hmm.
the commandant was from the 38, from the 33 Assam Rifle. During that time when
No, no,
the
that
when
is
the state was
okay.
filed, Lordship.
Whoever is there will file.
Yes,
But then there is nothing stated in the WS that he has been authorized.
still, Lordship, the commandant respondent for is also one of the party.
Chief of Army Staff, Director General of Assam Rifle, DIG, Commandant Territory Assam Rifle. Okay, so he is defendant number 5.
Defendant number 4.
Defendant,
5.
he is
Five.
defendant number 5.
5, yes.
But
And he has signed.
But what they are saying is, there is nothing to say that he has been authorized by the respondents number, defendant number 1, 2, 3, 4.
Lordship, I have not mentioned that I'm
It is not
I'm
mentioned.
filing on behalf of respondent number 1, 2, and 4. I'm filing on myself. I have not stated.
No, no. Here, see, written statement 4 and on behalf of defendants 1, 2, 3, 4, 5, and 6.
Yes.
That is your WS. Whereas you have not stated anywhere that you have been authorized by the other defendants. That is what they're trying to say.
Since the land is occupied by the then commandant, so he had signed the affidavit and being the agency of the Ministry of Home. He is the
Oh, see,
duly authorized
when
agent of
even
the government.
of Nagaland is also impleaded as a party, when the secretary or somebody signs, he says, I'm filing on my own behalf as well as being authorized by, the chief secretary and whoever is there. Anyway, that is the record, so we have to go by the record.
And with regard to the exhibit, Lordship,
Hmm.
all my documents has been exhibited by the plaintiff. So
Hmm.
there was no other new documents. So we have not exhibited any documents, but we have relied on the documents that has been exhibited by the plaintiff. Then with regard to the framing of issues for non-joinder parties, Lordship, I have made an application for dismissal and of the civil suit for non-joinder of necessary parties, but my application has been rejected. During the framing of issue, I have also given non-joinder party as one of the issues I have suggested, but the court has not the court has not accepted my my suggested issues on non-joinder parties, Lordship. Then, Lordship, the two agreements.
You filed the application, praying for, you were saying, which was rejected?
For rejection of the written statement for non-joinder of necessary
Non-joinder.
parties, but that has also been rejected by the trial court. I have
Certain, because LCR
And-
is
We'll
before
see
the
from
lordship.
the record
Yes.
Yes.
whether it is there.
It is there.
Now, Lordship, all the documents, the agreement, there was two agreements that was been signed, endorsed, signed by the additional deputy commissioner. The first document was signed by the additional deputy commissioner. The second agreement was signed by the deputy commissioner, Mon. And the land permit was issued by the additional deputy commissioner, Mon. So in all this dispute, the state was also a necessary party, because because the land was acquired by the state, that was being given to us, to the Assam Rifle. So we don't know whether that disputed land that they are claiming falls within the land that was donated to us or not. And it is only the state government the LRSO, that can decide whether that disputed land falls within the land that has been given to us or not. Assuming that the Assam Rifle, they have encroached some part of land, well, that has to be ascertained whether that land belongs to that encroached land or to the land that has been donated to us. And without the state government, how can the court just decide on the issue that the land belongs to the land that has been encroached by the Assam Rifle? In the question of non-joinder parties, Lordship, let me keep one citation, Lordship. GLT 2018 for GLT 549.
Sarah?
Lordship, in the head note B, Code of Civil Procedure 1908, Order 1, Rule 9, non-joinder of necessary parties held. Onus lies upon the defendant to show that the suit is not maintainable for non-joinder, and the plaintiff intentionally, in spite of being aware, left out the said necessary party out of the suit. So the plaintiff, they have intentionally left out the state government as a party respondent. In spite of knowledge that the state party is a necessary party, because the land was acquired by the state government that has been donated to us, the permit to the plaintiff was given by the state government. So they are a necessary party. And only the state government can say whether I have encroached the plaintiff's land. But without any verification from the state government, the court has come to the conclusion that the land falls within the encroached land. And the saddest part is that, Lordship, the court did not believe the statement issued by the highest authority of the village. If my Lordship may come to page 33 of my appeal. Page 33. Sorry. Lordship, from bottom, paragraph 2, Stephen DW3, DW4, Lordship got it?
Yes, TW3.
TW3, TW4, TW5. That is the village chief head GB and the village council chairman had stated in this deposition that as per the interim agreement, that is so and so, and the survey map issued by LRSO of DC Mon, it is clearly showed that Mr. Chili Kongyak is running a shop on list to Mr. Mahesh Agrawal within the 50 acres of land acquired land already sold to the Assam Rifle by the Konkan villagers. With regard to the aforesaid deposition of defendant number 3, defendant witness number 5, from a perusal of the interim agreement dated 27/10/1978 and the sketchmap exhibit B6, it cannot be discerned that the disputed land falls within the 50 acres of land acquired by the defendants. The agreement dated 27/10/1978 is silent about the disputed land, though the canteen on the disputed land finds mentioned in the sketchmap, Lordship. But it cannot be discerned whether the disputed land falls within the 50 acres of land occupied and subsequently acquired by the defendants. On other aspect of the matter is that defendant witness number 3, defendant witness DW4 and DW5 are the highest authority and officials of the Konkan village holding the post of ANC, village chief, head GB, and village council chairman, respectively. And it is very unfortunate to note that in respect of the instant case, they had disposed not on the basis of their own knowledge, but on the basis of the documents, Lordship. That is the interim agreement and the sketch map. Though there is nothing wrong to dispose based on a document, but it is in the instant case, the 3 DWs being the highest authority of the village, they should have knowledge of all such dispute within the jurisdiction of the village. So when there is documents, Lordship, they have stated as per the documents. They have stated that the disputed land falls within the land that has been donated to the
Within the 50 acres.
within the 50 acres of land. Yes. It is the ANC, the GB, head GB, and the village council. They have disposed that. But however, the court did not believe in the authority of the highest authority of the village. That's given by the highest authority. So if we do not believe, then there is no necessary of having an ANC or a village chief. Any private person can come and claim that it is their land. So unless and until my lordship, in conclusion, lordship, I say that unless the state government is made a party respondent, this dispute cannot be settled. Since the right person to state whether the land belongs to falls within the 50 acres of land or not, it is the right party is the state government, the LRSO, that can decide whether that land belongs to within that 50 acres or outside the 50 acres of land.
Anything else? That's all.
Lordship, the record will speak.
Heard learned counsel for the parties. Orders reserved.
Hey, comfortable. Comfortable, no.